got 3 scheduled speakers, and as I stated at the last meeting was to kind of get an understanding of various issues going on throughout the state, and throughout, just specifically with HOAs. Today's meeting is we're going to be hearing from the industry itself. So from folks that work in HOAs and are involved in their association. We're going to hear from an attorney, and just kind of learn more about process, and hopefully learn about citizens' rights. And again, as I stated, throughout all of this, and I'm going to restate it throughout all of this, we're here to listen, and we're here to learn, and we're going to hear about the issues, and we're going to seek solutions. And that is, we're not here to ban HOAs. We're not here to hate our neighbor. We're here for one reason, and that is to find a solution to a problem. And we know there's lots of problems, and we're going to find lots of solutions. So, so there is at 10:15. We got word just a couple days ago. The governor has a big announcement at 10:15, and I do not want to cut anyone short when we get to public comment. So, at a little bit before 10:15, I'm actually going to recess, and then we will come back after and do public comment. Okay, so for those of you, I know some of y'all might have driven a long way to speak, and I don't think it would be fair to you to make you get up there and speak for 30 seconds, because that would be about where we're at. They told me 10:15. Oh, well, maybe we won't recess. Well, while we're going, I will we'll confirm all that. So I thought it was 10:15. So anyway, all right, shows what I know. I blame Mercedes. I'm just kidding. All right. So with that being said, so if y'all would, let's get started. I'd like to everyone to bow your heads with me and let's pray. Dear Lord, thank you for this day. Thank you for all that you do for us. Thank you for the beautiful nature that you provide for us. And thank you for allowing us to be patient and listen and do your will. In your name we pray. Amen. All right. First up, we have John Kruger. John, you can either come down here or to the podium. Podium's better for TV. And John is a VP of Government Affairs at Associa, which is the largest HOA management services company in the U.S. Is that accurate?
That is correct.
Okay, John. John, you used to work up here at the Capitol, didn't you?
I didn't work at the Capitol, but I worked for the State Chamber for 5 years.
That's what it was. Yep. Okay. So, John, the mic and the floor is all yours.
Terrific. Good morning, Mr. Chairman, members of the subcommittee. I do appreciate the opportunity to be here today and offer what I hope is helpful testimony in this issue. As stated, my name is John Krieger, and I am employed by Associa, the largest management company in the country. We have over 300 offices in 42 states, including multiple offices here in Georgia, serving numerous communities. And I say that not as a point of bragging, but really in the context of, as we look at public policy changes, our breadth and depth of service, seeing the problems around the country, working with legislators to try to address these issues, we hope we bring a good perspective on what works and what doesn't. An interesting note about our company is our CEO, who started it 45 years ago and still runs it, also served 24 years as a state legislator. So he's been on your side. And I think that's why we're the only company that has full-time government affairs staff to engage in this process and hopefully be helpful. As most of you know, there are an estimated 2.3 million Georgians living in more than 11,200 community associations. Personally, I've lived in HOAs for over 25 years now. Some of you may say, you're crazy, but I've had great experiences. And in fact, when I lived here in Georgia, I actually served on my board for 4 years and learned a lot about communication and hopefully addressing problems. With that in mind, I'd like to begin by kind of reminding the committee members the basics of how associations are created and governed. Before one shovel of dirt is moved for either townhome community, condo community, HOA community, they're created by the developer filing a declaration in the county's property records where the association is located. The declaration contains the covenants, conditions, and restrictions known as the CC&Rs governing the property. It also contains the bylaws establishing the operational controls of the association, including meetings, voting, duties of the board, document retention, and access to records. For simplicity, I'll refer to these as the governing documents going forward. Beyond these governing documents, there are also multiple state statutes that govern the operations of community associations. Most, if not all, are formed as nonprofit corporations, meaning they're subject to Georgia's Nonprofit Corporation Code. In addition, condominiums are governed by the state's Condominium Act. And finally, property owners associations, or POAs, are governed by the state's Property Associations Act. My point is, there are already varying levels of statutes governing this industry. That said, as I'll share in a few minutes, there are opportunities to address some of the concerns raised by your constituents and witnesses and others living in this form of housing. I'd like to spend a minute or two highlighting the board, who is charged with managing the association. These are volunteers who are democratically elected by their fellow residents to serve. As volunteers, they are not paid, and the job has a significant level of responsibility. They are fiduciaries of the association's funds and are expected to exercise good judgment, making decisions in the best interest of the community. As I mentioned earlier, the governing docs provide details regarding those duties. Now, this committee has heard previous testimony alleging board member misbehavior and falling short of those expectations, and I'm not here to defend those. But I will say that in our experience across the country, the vast majority of board members have the best intentions and fulfill those in service to their neighbors. Speaking of duties and responsibilities, it's important to understand that there are also expectations of homeowners when moving into these associations. The highest of these is paying their dues and complying with the deed restrictions governing their home and property. I can tell you that many conflicts between owners and board members result from that second responsibility, and there are a couple key reasons for that. First, homeowners who buy homes in these communities are sometimes unaware of the rules because they may not have read them or understood them. The governing documents can be very lengthy, and sometimes an owner doesn't receive them far in advance of the real estate closing or looks at them until they're at the closing table. And it's unrealistic to expect them to read all those documents when they're signing them. Second, owners can become very defensive if they're unaware and don't like that they're required to seek permission in advance before making changes to their property, like painting their home, replacing their shingled roof, changing landscape, etc. I call this the conflict between property rights and contract rights. Too often a property owner decides it's their right to do with their property whatever they choose, which as a property owner, I understand. But that can conflict with the contract they signed, agreeing to abide by the rules and restrictions governing their property. And those rules and restrictions often change based on votes of the members. I wish, as I deal with these conflicts in legislation across the country, the one gap I see is I wish there was an opportunity to educate homeowners before the closing table on what it means to move into an HOA, because that would avoid a lot of these conflicts. Next, I'd like to discuss the enforcement controls available to boards for violations and delinquencies. Regarding violations, when an owner doesn't comply with the deed restrictions governing their property, the normal enforcement is through fines. And I want to stress this. The goal of deed restriction enforcement is compliance. It's not the collection of fines. Now, again, there may be outliers to that, but the community functions best and property values remain highest when owners comply with these restrictions. Here again, this requires a certain level of conformity, and that can cause tension with the innate desire for freedom and autonomy over one's property. Again, I'll admit to you that sometimes boards can be overly zealous and punitive enforcing their deed restrictions, and I think you've heard examples of that. Next is assessments. Assessments are the dues owners are required to pay to fund their association. I mentioned earlier that associations are nonprofit corporations, so the dues are set and divided among owners based upon the annual budget adopted by the association. And those budgets and dues can vary widely depending on the amenities that the association may offer and for which it is responsible. My point here is the collection of dues is critical for the operation of an association and the common use areas enjoyed by all owners within a community. Community amenities, common areas, and services afforded to residents cost money to operate. And when some owners are delinquent on their payments, it puts a strain on the association that can result in either a reduction in service or a requirement that all owners who are already paying their dues have to pay more to make up for those delinquencies. Enforcement of deed restrictions violations seek payment from delinquent owners by sending reminder letters, and when that doesn't work, they seek help from collection agencies, during which delinquencies can grow due to late fees, interest, and those collection costs. As an HOA homeowner, those owners have certain financial obligations that cannot and should not be shifted to the others, and that brings in lien and foreclosure, much like mortgages and property tax payments. If HOA homeowners are delinquent, they are afforded same protections of notice and judicial protections afforded those delinquent on their mortgage or property taxes, and I think we're going to hear more of that from a future witness. Foreclosure is intended to be a last-ditch effort to get the attention of delinquent homeowners. Like with property taxes and mortgage notes, this tool is a necessary enforcement mechanism to assure that owners are meeting their obligations and not shifting those to others in their community. And I'll also tell you that it works, and it's a hostile process, someone being foreclosed, but only a small percentages of foreclosure filings end up in foreclosure sales. Now, as I mentioned before, I've never denied there are challenges in this housing model with more than 2 million Georgians living in community associations. But I would just caution the committee to weigh the extent of the problem and the potential impact of any statutory remedy on all owners that you may propose to avoid adding costly new regulations for homeownership, especially during this time of rising housing costs. With that as background, I'd like to conclude by sharing some possible considerations to address some of the issues I've raised. And I know it sounds cliche, but it is a challenge, and I've seen this all over the country. It is a challenge to find one-size-fits-all solutions, especially when communities vary greatly. First, communication. It sounds simple, but a lot of conflicts begin due to a misunderstanding, which can quickly escalate due to a lack of or simply poor communication. Associa works with our client boards to ensure owners are provided clear written communication of any violations or delinquencies before the problem and costs escalate. There is also an opportunity offered for an owner to dispute a violation. Our clients provide owners grace periods to cure the violation or delinquency before they escalate. I'm not sure all communities offer that, so that might be something the subcommittee might want to look at. But as a former board member, let me propose that owners can assist this process if they respond to communications sent by the board. I experienced this and have read in news accounts where owners have ignored notices and accounts until they're turned over to collections and fees escalate to the point of lien and foreclosure. Effective communication from both boards and owners can help alleviate conflicts. Regarding fines, as I just explained, there are due process steps that can be offered before they escalate. I've mentioned before, collections of fines is not the goal. It's simply a means to encourage compliance. And sometimes those fines can be substantive depending on the violation. Explaining violations in a written notice and offering a cure period and hearing opportunity can reduce those from escalating if owners engage in this process. Foreclosure, again, it's a drastic last step. And Associa, I'll tell you, has worked with legislators in other states to differentiate between foreclosure for fines and foreclosure for dues. And we've partnered to prohibit foreclosure based solely on fines and collection costs for fines. While we support protecting foreclosure to protect the financial viability of an association, we understand that an owner should not lose their home because their grass was too high or they had a torn solar screen, which has unfortunately occurred in some extreme cases. Most communities offer delinquent owners a payment plan that can assist, particularly when an owner is facing an economic hardship. Members, I've worked on these issues in numerous states, and I can tell you that associations are not looking to throw people out of their homes, but they are serious about collecting their dues because they have a fiduciary responsibility to collect those debts. We believe that anyone buying a home in an HOA community should be aware of those requirements. Dispute resolution. Disputes in the community can have negative impacts on the entire community. That's what motivated me to seek election to my HOA board. At the end of the day, homeowners are desperate for some alternate venue to resolve disputes that doesn't require them to hire and pay for private legal representation. As you've heard through past witnesses, that can be expensive and often difficult to even find an attorney willing to take the case. I get that. There's been some discussion about creating some state-level ombudsman or administration. I'll tell you, there's 7 states that have some form of that, but only 4 of them offer little more than information. They don't help in disputes. And Nevada, Florida, and to some extent Delaware have some authority, but I haven't found it to be effective. So I'll just tell you that on the record from our experience. And part of that is because there's some key questions that have to be answered about these disputes. Which parties can utilize this process? Is this homeowners accusing board members or filing complaints against board members? Is it board members being able to file complaints against homeowners? Is it homeowners versus homeowner? You have to decide who gets to use this process. And then over which issues? Is it disputes of law? Is it disputes of interpretation and enforcement of the governing documents? Is it nuisance disputes between owners? Then finally, who bears the cost? Is it the state? Is it the association? Is it the members using this process? So these are really serious questions that, again, I've not found any state that has really answered them effectively. Now, as I conclude, I'll share what I'll consider some best practices that are utilized by associations and management companies, and in some states have memorialized these in statutes. Going back to the beginning of my presentation, community associations are formed with the legal structure in place to self-govern. And association members have the power to elect new boards and set new policies should a majority of them exercise that. But as you've heard from some testimony, that doesn't work in all cases. And the state can play a role in curbing unlawful or abusive behavior. So here are some quick suggestions. As I mentioned earlier, require associations to provide owners clear written notice of a violation or delinquent assessment and identify the risks of a potential penalty before they assess that. Provide a specific amount of time for owners to cure a violation or delinquency before assessing the fine or fee or turning the account over to a collection agency. Now, I will note for the record, there are some violations that can't be allowed a cure period if there's a threat to public health and safety, and certain states have addressed that. Then provide an opportunity for owners to meet with the board or an independent committee to discuss and try and resolve a dispute or violation. But again, this can't be for dues. Dues are contractually owed based on signing to live in the association. So you can't provide dispute resolution over dues. Then if that doesn't work, consider requiring mediation or arbitration prior to filing litigation. And the parties can determine who those mediators or arbitrators are and whether they want to abide by those decisions. But again, it provides hopefully a less hostile and lower cost, though that's not often the case, lower cost venue to argue issues. And then if all else fails, I think you have to still provide either party the opportunity to pursue in court. As it relates to foreclosure, ensure potential home buyers, HOA buyers, are aware that failure to pay dues can result in liens and foreclosure. Ensure adequate and confirmable written notice before filing a lien or foreclosure. Prohibit foreclosure based solely on fines. And then what other states have started doing is, a few of them, is providing a right of redemption should that foreclosure sale actually take place. The goal of these policies, and I would request of any statutory changes you might pursue, is empowering homeowners with transparency, due process protections to limit cost, an alternative route than the courts to seek resolution, while at the same time maintaining associations' authority to enforce the restrictions and collect their dues. Mr. Chairman and members, I've submitted to staff some summaries and links to some laws in other states that have tried to address this. While I'm not endorsing any one of them, I think you'll find many of them meet the objectives that I just proposed. And with that, I thank you for the invitation again, and I offer, not just today, but going forward through session, if I can be a resource to any one of you or your staff, please feel free to reach out to me, and happy to answer any questions.
Thank you, John. I've got a couple questions. So, for committee members, there's a summary of laws from other states that are in your packet, which is very helpful. So, thank you for providing that. I do have one question, and it mentions in Nevada, an owner may also request a hearing to contest the violation before disciplinary action is taken.
Yeah.
Who is that hearing with?
Let me pull it out. I think it's
And
with the
just
real
kind of
estate.
a-
I think it's with the Real Estate Commission.
With the real estate, okay. And that kind of leads to my next question. So if an HOA is, what you mentioned earlier, they're all set up as nonprofits, or most of them are, not all of them, but should they choose to, but most of them are set up as nonprofits, so they fall under nonprofit laws. If they are not following those laws, who has oversight over the HOA?
If the boards, in most states, it's the courts. And just looking at this, the Invitation Nevada is I think it's a hearing before the board. So
Before the
within
board of
community.
commission, the real estate commission?
No, before the HOA board.
Okay.
Yeah.
All right. And guys, let's just maintain decorum in here and keep your comments for the microphone, please. Okay. Let's see. So you're saying if a HOA is let's say they're out of line, and they're not following the law in the eyes of the homeowner. Mm-hmm. In this state, where they would go to the board?
Well, the complaint is against the board, so they could either have a meeting with the board, but if the board still is not in compliance, then the courts.
Their only remedy would be the
to
courts.
sue.
Okay. All right. Is there other states that have a different process? I saw. Let's see.
I mean, this isn't an exhaustive list, Mr. Chairman. I could have sent you 20 pages. Really, the idea is what I've been trying to propose is make sure they have an opportunity within the community to get a fair hearing with their board or a committee of members in the community. If doesn't provide the remedy, then that's what I'm talking about. The next step could be consider seeking a third-party mediator to try to mediate this. And if that doesn't work, then, the step would be litigation.
Okay, so I'm on page 5 of your thing, and I'm just asking questions.
Sure.
I'm trying to learn here. So also in Nevada, it looks like they've got kind of a 3-step process. You first is a referee. There's which is a neutral third party. They hear the dispute, review evidence and governing documents, and makes a non-binding decision. And then it moves, I guess, if it escalates in the...
I think those are 3 options that they use.
3 options,
Yeah.
okay.
Yeah.
All right, and I'm reading this for
from
the
page
public
5.
here. So the other option is mediation,
Yep.
which parties provide the mediator a statement and relevant documents, including an acceptable resolution, and the mediator works to resolve the dispute with a written agreement. And then you have a non-binding or binding arbitration. That's when if mediation fails and both parties agree, they can present their case and the arbitrator renders a decision.
Yeah.
So, and then you've got a note, Nevada uses a formal process requiring the claimant to fill out a complaint form and serve the respondent before taking any action.
Yeah.
In this state, just so I'm clear, we don't have anything like that, right?
No.
Okay.
This is one of the 3 states that have some level of state authority with this commission.
Okay.
3 options for trying to resolve the dispute after they file a formal complaint, and that is reviewed.
Okay, and
by
do
the
you
commission.
know, and if you don't, that's okay,
Sure.
do you know who pays for, is this like a line item in their state budget? Is it loser pays? What do you know?
You know, I apologize, Mr. Chairman. I don't know that
No,
offhand.
it's okay.
I can find the
We
answer
can
and
look
submit
that
that
up.
to
We
Mercedes.
can look that up. That's what I'm curious about. And
Normally, these processes are you either pay an initial fee, the person that wants to use these, and then the parties split the cost. But I didn't put that in there, so I don't want to say. But my recollection is a lot of times it's whoever wants to use this process has to put up a certain fee to be able to utilize it. And then,
which in most cases is probably a lot less money than having to hire an attorney.
yeah, I mean, I think the initial filing fee is $50 in one state, $250 in another.
Okay.
So again, the whole point is it's less costly than the court, but that doesn't prohibit either party from having counsel. at
Right.
these.
Right. Understood. Okay. Any other questions from committee members? Senator James?
Thank you, Mr. Chairman. Thank you very much for this comprehensive report. My question is, right now, in the state of Georgia, do we have any process other than the courts? And yes, answer that.
Yeah, Senator.
That's what I.
Thank you. Yeah, currently there is no formal process other than, hopefully finding the practice of allowing a homeowner to meet with their board or a committee that's not in statute or litigation. Now, I don't think it prohibits anyone from utilizing other services, but there's no requirement of that, and there's no state authority that has oversight.
Well, on the different states that you've given us a brief view of what they're doing, they had to put this in law. Who oversees most of this? Is it?
It's the courts, and
So the court has to be involved either way.
If it's not one of the states that have some limited, Nevada, Florida, or in a small case, Delaware, if it's not one of those states, then it would be, again, the courts.
I think my concern is, since the court is involved and the member of the HOA has the complaint or concern or the charges against them, they're paying for the lawyer that the HOA is using.
Their dues do go pay for that.
And so, but they have to go and spend money to
For
get
private.
an attorney. So we need to make,
That is correct. And I should say, these other options, one thing I'll say, and some don't like it, the protection of judicial oversight is helpful for creating a record in many ways and can create precedent, which doesn't happen in mediation or arbitration. So there is some, although many don't like the court decisions, you have, arbiters of the law overseeing the facts of the case, applying the law or the governing documents. So there is some protections in that process. I would just state that for the record.
my last question, Mr. Chairman. Since you're our expert and we're enjoying knowing what all these other states are doing, do you think that one of these can apply to us better than any of the rest of them, since you've done your study?
Yeah, and I don't want to put myself out as an
Okay.
expert. Well,
I mean,
certainly our
you're-
company's experienced, and
Yeah.
we do have some, experience across the country.
Yes.
I really think, going back to how these associations were created, they are created and the protection put in place for self-governance. I like ensuring, which Georgia does not have right now, ensuring that there's a clear written notice of a violation, opportunity to either cure or have a hearing with the board or an independent committee like some states have done, and solve that within the community. I think when you start going outside, it automatically starts raising fees. It automatically delays decisions, and you may not find resolution. So really my recommendation is look at ways to strengthen due process within the community to make sure they have the right to be heard before these fines or the penalty is put in place, or they're escalated or turned over to collections. And there are several examples in there of states that do that.
I do want to know too, what do you think about an Osbusman program in the state of Georgia? Oh, you did?
Yeah, he already talked about that.
Yeah.
There's
What
7
is it?
states that currently do it, and they
Yes.
haven't seen much success in any of them.
Oh,
So,
Again, it's a layer of costs and delay. That's not criticizing them, but I just have not seen that it solves what your constituents are looking for.
thank you very much.
Senator Beach.
Out of all these states that you've given us examples of, is there one that you like best?
That's a good question, Senator. And I've tried to look at that, and I don't. I think there's a combination of some things that have been done in several states that can be looked, that I would consider, you all looking at. But I don't see one state that from start to finish does it perfectly.
And let me ask one other question. I live in the city of Alpharetta. My subdivision's in the city of Alpharetta. Do you think code enforcement at a city could play any role, or the city council or the county or the city manager, or anything to do with the city? And I know some are in unincorporated counties, some aren't in cities, some associations, but for those that are in cities, do you think that our code enforcement folks could play a role in working with the HOAs?
There may be a role. I think there's an attorney that might be able to answer that more clearly. I will say this, again, this is just experience in other states. There are certain law enforcement parking violations that HOAs have looked to local law enforcement, and local law enforcement has refused to enforce. So I think you might be straining the department's budgets, but whether legally that could be, I'm not aware of, code enforcement being used to assist in the operation of HOAs around the country, though, local cities or counties. And in fact, like I said, a lot of times when there's certain activities that are expected, the city and counties, communities have often been disappointed because city resources have been strained, and to do that has been a lower priority.
Gotcha. Thank you.
Okay. Senator Rep.
Thank you, Mr. Chairman, and good morning, sir.
Good morning.
I was just wondering, is there a monetary fine threshold amount that must be exceeded before the litigation process takes place? Let's say, for example, my mailbox, the paint is dull, so they fine me $100. Would that eventually, if I don't pay that, is that a threshold where it might eventually lead to a lien and a foreclosure just because of a mailbox not painted?
Under current law, if those delinquencies from fines and collection costs reach $2,000 in Georgia, that can become a lien, and the association can move to foreclosure under current law.
Thank you.
Okay. We got other speakers too, so y'all can ask them as well. So, John, I appreciate you being here. And I should have said this before you started. But I want the public to understand, in kind of my journey through this, what I'm learning is there are HOA companies out there that are doing things right, and there are also ones that are doing it very wrong. And, anytime we are trying to separate the good from the bad, unfortunately, sometimes the good gets punished too. And that's unfortunately just the way it goes. But I want everyone to understand that just because you're having a terrible situation with your HOA, it doesn't mean everyone is. And so just keep that in mind. And so as we're trying to sift through all this and we're trying to separate all that, that is what we as legislators have to do. We have to keep them separate, and then thread the needle and figure out what solution is going to work that, punishes the bad actors and punishes the least amount of good actors. And unfortunately, there will be some good actors that get punished a little bit too, but we will try to keep that to a minimum. So that is what we're looking at. We having other states and what they're doing is very helpful for us. It lets us kind of see what else is going on out there, other benchmarks that we can look at, And that way, we're not necessarily starting from scratch. And again, you know, Senator James has done a lot of work on this, so I don't feel like we're starting at ground zero, but we are starting fresh. We're putting new eyes, new ears on this, and we are going to try to figure out as much of this as we can. So again, John, I appreciate you being here.
Thank you.
I'm sorry, Mr. Chairman. Can I ask him one last?
Sure, but we do have two other
real
speakers that are
quick.
both
Okay.
experts as well.
Okay,
So
but-
keep that in mind.
You mentioned the $2,000 worth of liens.
Mm-hmm.
Like, for example, if he had the $100 wrong color on his mailbox, and then they would continue to add fines to the fines, late fees and things like that, right?
They could.
Okay, suppose so that means that whether your house is 250,000 or 2 million, is the same is 2,000 that they could foreclose?
Yes. Yes.
So it has nothing to do with
Value,
our
yeah.
Georgia law?
That's under current law,
Yeah,
correct?
it is a threshold of the delinquency.
Okay, I
that's-
just wanted to make sure that, that's what I thought, but I wanted to make sure.
Yes, ma'am.
Thank you very much.
And that's one thing you and I are going to be looking at.
Okay, thank you.
So
Thank you all.
thank you again. Okay, excuse me. Where'd my agenda go? All right, next up, Austin Hackney is our Executive VP at the Home Builders Association of Georgia. Austin, we appreciate you being here. For those of you that don't know, Austin has been here at the state capitol lobbying on behalf of home builders, many different issues, and so we asked him to be here to kind of bring a perspective from the developer side and the purpose and how they utilize it. And so, Austin, you have the mic and take it from here. Thank you.
Thank you, Mr. Chairman, members of the subcommittee. Appreciate the opportunity to present to you this morning. And I do have some best practices to share, some really just original use for an HOA and why, you know, the 99% of the HOAs out there are a good thing. And I notice observing the meeting one of this subcommittee that a lot of the issues that were described were related to the transitioning control from the developer to the HOA board and the homeowners, and that conflict resolution was another issue that came up several times during testimony. So I want to focus my remarks to some best practices for setting up an HOA and some for the transitioning of control to the homeowners and for the conflict resolution when those inevitable conflicts do arise. And I've got some slides to present to that effect, and members of the committee, you have these summarized in a 2-page document in front of you. So best practices for setting up an HOA. There's nothing groundbreaking in here. Early planning and clear documentation, transparent financial structure, and community involvement are at the top of this list. When we talk about early planning and documentation, we're talking about hiring a serious legal counsel to develop these documents, that these documents are going to be different with every community that they are created for. There's no one-size-fits-all CC&R. They're all different for the communities. And in these documents, they need to be clear because they're going to be defining the HOA's powers and the homeowner's obligations. And from meeting one, it seemed like that's the crux of the issues that we're talking about. For transparent financial structure, this wasn't really an issue that got brought up last week or in the previous meeting, but there are plenty of examples of HOAs with financial issues. So having a transparent financial structure early on from the outset is going to be key in limiting the opportunities for those financial negative outcomes. And then community involvement. This is, the HOA in its, essence is made up of the homeowners. And so when the homeowners take over the HOA to actively manage on their own, that they need to be involved from the earliest stages of the development. So let's get into the transitioning of control of the homeowners. We can talk about that. In the phased control transition, There are a couple different ways that happens, and we'll walk through the steps of that. And apologize for the small text here. I'll try and summarize it for those of you who don't have the document in front of you. But the idea is that the control of the HOA remains with the developer from the outset. They have made the investment, they're building the infrastructure, they're in most cases selling lots to builders to create these homes for the homeowners. So in the initial developer control, the developer or the declarant is appointing members to the HOA board, typically employees of the development firm or even site superintendents for the building firms. But these early stage HOA board members are there to make sure that the original vision of the subdivision of the condominium building remains through the construction process. And the trigger for the partial transition, when the developer begins to move control of the HOA into the homeowners, it varies subdivision to subdivision, project to project. It could be 75% of lots have closed and been sold to homeowners. It could be 90%. It could be the last lot available has been sold, and then the transition begins to the homeowners. And I'll just say quickly, the reason that this gets transitioned or that there are triggers that are different from community to community, the reason that a developer would not want to transition too early could be things such as, I mentioned that original vision, but a lot of these HOAs have architectural controls. They want to make sure the community has a certain look for all the home buyers. So if that transition happens too early and a group of homeowners wants to theoretically raise their property values by requiring all the subsequent houses to be built to a different standard, well, that is under the purview of the HOA board. But, for the original vision of the subdivision, those new standards may not pencil out financially for the builders, for the homeowners, for the market, for that community. So, and then on the other end of the spectrum, you may have a group of homeowners who want to see more affordable housing in their community, which is a perfectly reasonable goal. But then all of a sudden you've got half of these homes sold to people who thought that their architectural standards were going to be one thing, and they've been taken to a different area. So there are some very good reasons that for transitioning the HOA from the developer to the homeowners and having that trigger be different for different situations. For an example, if that trigger was related to just a random a set of years, so 5 years from the beginning of construction for the subdivision, something like the Great Recession could happen, and all of a sudden 5 years go by when those lots couldn't even be sold, and we get into some strange areas there. So my request, as the committee looks for potential solutions, if a transition trigger is on that list, that it be limited to the sales cycle, so that it could follow a 75% of lots sold, 90% of lots sold, final lot sold, but that really has the direct impact on the transition there. So the full transition after the period that has been identified in the covenants and the CC&Rs, then the HOA is fully turned over to the homeowners. There's a lot of best practices that I can share with the committee about, what the homeowners need to be reviewing for the all the bylaws, all the meeting minutes, all the financial documents that the developer-controlled HOA has had control of up to this point. Now the homeowners get all of those administrative responsibilities along the way. So the documentation of the transition process, I mentioned some of those documents, but this is really where the property management company should be coming into the picture and handling this transition process. So conflict resolution and HOA covenants. Obviously, this was really the biggest piece of meeting one of this subcommittee was these dispute resolution mechanisms, and the previous speaker spoke to really a lot of what I've got in these slides, and apologies again for the small text, but most HOA covenants do include some type of process for conflict resolution, whether that's internal and it's between the homeowners and the board members, whether it's outside of that relationship and bringing in a third party to mediate or arbitrate those disputes, and then finally formal legal action would be at the end of that list of dispute resolution mechanisms. The biggest thing is, as the previous speaker said, clear communication about what those expectations are, about what those next steps are for the grievances that inevitably will come up in these relationships. So clear enforcement policies is really at the top of the best practices list for conflict resolution. I know there are a lot more homeowners signed up to speak today about their specific issues with their HOAs, so I don't want to take too long talking about best practices, but happy to stand for questions if there are any.
Yeah, I've got a couple. So you mentioned on your sheet here under the full transition after a specified period or when most homes are sold, is there that specified period that you're saying that changes from community to community?
That's
like
correct.
There's certainly no law around it,
That's
right?
correct. That's right.
That makes that clear. Okay. And then under your initial developer control, is there, when they're putting members on the board, when the developer's putting members on the board, is there any specification on them having to live there? I don't believe there currently is in law.
No,
Does
not on the developer control.
Okay.
As it transitions to partial control and then the full transition, certainly there would be, residency requirements for that. But, for the developer's control, the idea is to keep it to that original vision, and typically those are going to be employees of the developer.
Okay, and then I guess what I think will be my final question. When the developer is building either amenities, or really probably the best example is a retention pond. That's probably the most common thing that homeowners are going to be responsible for when that developer leaves. Does the developer have any responsibility for, say, that retention pond once he hands over full control of the board? And maybe there's a dam or something that's going to need upkeep down the road. Is that, is there any kind of bond there? Is there, just trying to figure out, because that seems to be a problem too. Like there's, homeowners, you might come in and buy a home in a 30-year-old neighborhood, and one of the amenities all of a sudden needs to be upgraded, and all of a sudden you're going to get a huge assessment. And so I'm just trying to figure out that piece of it as well, because that seems to be an ongoing issue.
Certainly in most new subdivisions, the city or county does require bonding for things like the roads and some infrastructure, underground infrastructure specifically. I'm not 100% sure about the answer to your question for bonds for the retention ponds, but I can find that out and get back to you in the committee. I know that Georgia's construction defect law exists, but I'm not sure how far into the horizontal development that can be applied for the retention pond specifically. So let me do some research on that question.
Okay, that'd be helpful, because I think one of my concerns right now is on those types of requirements that's put on the developer and they leave. I don't believe there's any current law. And this may be a question for Julie when you come up, but I don't think there's any kind of law on a minimum of what a HOA has to keep in the bank. And so certainly when something like that comes due, that upkeep's going to have to be performed. All of a sudden, current homeowners are on the hook for it when you might have had 100 other homeowners come in and out and never had to pay anything for it, and so it's all lies on who's left.
Right.
And it's almost whoever gets the short straw is on the hook for it, and I think that's something we as a state need to figure out. Maybe Center Beach, I want to kind of put your CID brain around maybe a solution, and maybe there's rather than you take it out of the dues, it'd be more of a local tax that goes into a pot that maybe the city or the county manages or something like that. So I'd like to kind of encourage you to be thinking on something along those lines, because this is certainly a problem, and you might get into a situation where someone can't afford that assessment that's coming, and then all of a sudden they've got a lien on their house, and those are the things we're trying to avoid. And I don't think these HOA management companies are making money off taking people's houses. Their money comes from assessments, or really comes from the dues.
Right.
And that's the model that should work. And if it doesn't work, then they're in the wrong business. And so, and I certainly understand from a developer standpoint, he wants to protect his investment, and so it totally makes sense. And so, again, this is a case where I think the HOA serves the proper role in protecting the developer, but then it seems to me like there's a little bit of issue. We're running into more issues on the developer side of things during that transition period, and where you might have whoever they put in place to run that board, may not live there, and that transition may not be taking place fast enough when clearly the local homeowners might have more votes than say the developer. And so that's again a needle we're going to have to try to figure out, needle or thread that we're going to have to try to figure out. But I do think those transition, that phase, there does seem to be some issues, and so I look forward to working with you on trying to find those solutions. Certainly don't have one right now, but Senator Rep, you got a question?
I think Senator James was first.
Okay. Thank you. Thank you, Austin. How you doing?
I'm doing great. Good to see you.
Great. On the developer controlled, I guess, transition,
Mm-hmm.
they can decide who is on the board? Is that what I heard you say?
In the initial stages of the HOA, so we're talking about, half of the community may have been developed at this point or less, and the developer is still, could be still installing infrastructure, certainly still selling lots to builders under those covenants that would describe exactly what the house has got to look like. So yes, in those early stages, the developer is in control of the HOA board.
And they can just pick someone, they don't have to live in the district. So they can pick one of their employees?
That's correct.
Anybody?
That's right.
A management company or one of the foreign entities that have been coming in buying our land all over? So they can just select on their own, no process, no regulations?
That's correct.
Oh my, okay. And it appears that in all the transitions, they have your contract that you sign on the day that you're purchasing the home regulates exactly everything in there. So the developer can say you're going to have a swimming pool, tennis court, whatever, and clubhouse. And so many of the people in my community, even though I had an existing community, and now they built off of the different main streets, these subdivisions that are HOAs. And so not just my district, but my neighborhood, people are complaining because they don't know anything about these people who are on the board. The board ignores them, and they don't call the meetings on time, so they have nothing to do. When they get in touch with the developer, he has not put that clubhouse in yet or anything. And so then all of a sudden they sell it to someone else. So that's clear too. They can just do that too, even though you sign a contract and you have a covenant. They don't stick to the covenant, and then they can get rid of it, and the new person can make up new rules. Is that? I mean, that's what it appears to be.
You know, I couldn't speak to that specific situation without knowing a lot more facts, but it sounds like there are rules in place, there are governing documents that are potentially being ignored, and I'm not sure how to enforce rules that are already on the books that haven't been enforced yet.
But that homeowner has to comply with everything else in the contract, but they don't get the amenities that they were promised, and now they're not going to get them at all. So I know that, you know, I'm not criticizing anybody. I'm trying to understand if this is what's going on, if we need to do something in our legislation that encourages the contracts to be the same. You know, how could it be that I have 3 subdivisions off of my street, for example? All of them have different timelines. And maybe it's 6 houses on one and it's space for another 40. It's been like that for like 7 years now. And so these people with the 6 houses, all of a sudden, a new person is coming in building, and they've not had but 2 board meetings, and they had to really fight for that. So whose responsibility is that? They come to me, I can't help them unless I know exactly what's going on.
Right. You know, I don't know what the mechanism is for. I mean, it sounds like a contract between individuals that needs to be enforced. I can tell you from the developer's perspective, at least the developers that I work with, you know, the incentive for them to develop these subdivisions is to provide a community and homes for people to live in, but also to make money at their job. And so their incentive is to do what they say they're going to do, because the next community is going to look at their track record. So it sounds like in that situation where they got halfway through and had to sell, that potentially that didn't work out for the developer either. So that sounds like a situation that went negative and potentially is an outlier to the normal.
Okay, thank you. But we need to figure out something, and maybe the brilliant minds on this committee can look at that particular issue as well.
Thank you.
That is the purpose of this subcommittee. We are going to figure these things out. So, Senator Rhett, did you have a question?
Yes, just a quick question, and thank you for showing up today. I don't live in a subdivision. I live in a brick house with deer, chipmunks, hawks, squirrels, possum. Matter of fact, I had some possum stew last night. But just joking. But a quick question.
No, you ain't.
The homeowners' dues, are those set by the developers or the homeowners when they take over, or is there some suggestive guide to how much the dues might be?
You know,
And
that's
you're all welcome to stop by for some possum stew.
you know, I'll thank you for the question and potentially defer to the property management companies that are also on the agenda today. I'm not 100% sure when those dues amounts get assigned.
Thank you.
Thank you.
All right. Awesome. Thank you for being here. Appreciate your input. All right, next up, we've got Julie Howard. Julie is the co-founder and managing partner at Nowak Howard Community Association Attorneys. And Julie, I believe you are also the past board president for the Homeowners Association?
Yes.
Or
yes,
something like
thank
that.
you. Thank you so much, Senator Brass, Vice Chair James, Senator Rhett, and Senator Beach. I appreciate your hearing from me today. I am Julie Howard. I own the law firm Nowak Howard. My practice is devoted solely to representing homeowner and condominium associations, which I started doing 28 years ago. I've been practicing law 31 years, and my 28 of those have been devoted to representing volunteer leaders of their HOA and condominium typically almost exclusively after transition. So we are usually involved just while transition is taking place or after the community has already transitioned from developer control. And I am here on behalf of the Community Associations Institute. I am a past chair of the Legislative Action Committee. I'm also past president of the Georgia chapter of CAI and past president of CAI International. I was elected to membership in the College of Community Association Lawyers and served as the president of the college in 2018. I spend a lot of volunteer time for HOAs and condominiums, and it's my pleasure and honor to be here to answer your questions, to provide any information you need. I'm going to start, I want to go over the collection process, and I did provide a visual chart for that process. But first, I'd like to go answer some of the questions that have come up that I've been listening to in the course of this. First, our role as association counsel is to represent the corporation. So we, under state bar rules of professional responsibility, have a duty to the corporation. So when we're working to collect assessments, to advise the association, we're doing that as counsel to the corporation, like the CPA or like an engineer. We're not representing the individual members. And I think that I get that question a lot when I go out to association meetings, that I represent the members because they're paying our fees, and that's not accurate. We are representing the corporation, not individual board members, not the board per se, but the corporation. Also, regarding fines, Senator Rett raised the issue of fines. It so happens that one of the biggest cases in the last few years for associations was involving a mailbox. And so I appreciated your question. And the case was in Forsyth County, and the HOA was seeking $80,000 in fines, and the court found the fines unreasonable. And just last year, the legislature actually amended the Property Owners Association Act in response to that case that happened in Forsyth County, to provide some restraints on not suspending owners' voting rights when they are delinquent solely for fines, to provide for the right of an association to use self-help instead of suing to collect the fines. So there already has been some response for a case like that. And again, just so happened to be on a mailbox. So maybe you were thinking of that case. With regard to fines in particular, fines have to be reasonable. So there is already in this statute, in both the Condominium Act and the Property Owners Association Act, fines must be reasonable. What is reasonable? That is up to a judge or a jury. So an association cannot just go out and foreclose on an owner for fines, because they have to go through the process of proving that the fines were reasonable. And that's going to be a case-by-case basis. Senator Beach, you mentioned, couldn't code enforcement help? Our experience is that code enforcement says, we don't want any part of your private covenants, and they don't have the resources or the funds to assist. And what actually has happened over my years of practice is that cities and counties have transferred what used to be city and county's responsibilities, like the retention detention ponds, to HOAs and condominiums. Alpharetta in particular has done that. I represent communities in Alpharetta that have retention ponds, and the city changed the ordinance after this community was developed, which was in the early 90s. They changed the ordinance to require the HOA to maintain the retention detention pond. They were already in existence, and a lot of cities and counties have done that. So the cities and counties are not looking to help HOAs and condominiums with either services or enforcement. They're looking for the community to take that on themselves, which requires funds. And the only resource that an HOA or condominium has are the assessments that the association levies. And there is no other money for an HOA and condominium. And they are nonprofit corporations. There are a very few. We don't even represent any, and we represent hundreds of associations across the state. They are nonprofit corporations, and they're bound by the nonprofit code, which provides for, as John mentioned at the top, that there are fiduciary responsibilities. There's also an articulated business judgment rule. Directors and officers are bound under Georgia's business judgment rule to act in good faith, like a reasonable person would in like circumstances. And so there are already protections that require board members to act in good faith, to exercise their fiduciary responsibility. With regard to more on the retention detention pond, that is something that I have experienced with many of my associations as they have transitioned for developer control, because there's not adequate money to maintain the retention detention pond. CAI worked with Marvin Arrington Jr. several years ago because his own association had experienced that, and we did successfully added some changes to the Property Owners Association Act to allow for associations to have a mechanism to facilitate transition of control from the developer and to get more information. So there already are some changes in the law related to that particular issue, which is not new. And we don't have a reserve funding requirement in state law. Some states do have mandatory reserve requirements. I have seen that is an issue with HOAs and condominiums who are operating as a nonprofit with only the resource of the assessments on a shoestring budget, and it's hard to save. It's really hard to save when all the owners aren't paying their assessment. And so, but there is no requirement. I am doing tomorrow a reserve study class for our directors. We do monthly board training to help these volunteer leaders to know more about the law, to know what their responsibilities are. That's not a statutory one, and a lot of governing documents don't have the requirement either. So we have to rely on best practice to encourage associations to have reserve studies to see what their facilities need for capital improvement and repairs in the years to come, and set aside money from the assessments to plan for that, or including the retention detention ponds. So that is an area where there could be a legislative change requiring from the outset that there be reserve funding. We saw with the tragedy of Surfside in Florida several years ago, that community had not set aside adequate funds to repair their building. They couldn't get a special assessment passed, and we know the tragedy that ensued from that. So it is a real issue. Florida had legislative changes in response to that to help hopefully prevent that from ever happening again. So I wanted to address some of the questions that I heard. I want to talk now about the assessment process. Having done this for so long, I do see a pattern that the news stories are never the good news stories about HOAs and condominiums, because that would be boring and no reporter wants to report on that. But I am proud to say I have worked with hundreds, thousands likely, volunteer leaders of community associations over these 28 years who are there to help protect what is, for the most part, the biggest investment of every owner in that community's life. And they're there to preserve property values, to keep up the aesthetics and the rules that the developer initially set. And when they go off the rails, it is the most fundamental democratic process. The community can elect new leaders, and I've seen that happen as well. So I often say to the owner who is really angry with their board, run for the board. It's everybody's right. And so that is definitely one of the parts of the process. For the assessment collection, the stories that I see on the news are often, I hear, well, I didn't know my home was being foreclosed on. I had no notice. It just happened. That is not possible. That's not possible under Georgia law. The process in the visual chart shows that the first step is the board on an annual basis is required to adopt a budget. Through the budget, you have the assessment for every homeowner. Most of our clients are sending, 3 and 4 late notices to owners long before it ever gets to our office. But once an assessment is past due, then if we are involved as counsel for the association, we would send notice to the homeowner that's governed both by the Georgia Property Owner Association Act for those associations that have submitted to it and the governing documents, or the Condominium Act and the governing documents. Or if it's an association that's not subject to either, there's case law. And the Fair Debt Collection Practices Act. So there are multiple laws at play. There are multiple parts of the process that govern. There is, if someone is serving active duty, there's protection for military. If someone is in bankruptcy, obviously there's bankruptcy. You have to check who the owner is. So there are multiple parts of the process before that collection letter is ever sent. Then an owner has, under the Fair Debt Collection Practices Act, at least 30 days to dispute the debt and respond. So the first part is you would get that statutory notice, and you would have 30 days to respond. If you didn't respond and the association filed a lawsuit, personal service is required for the association to proceed with foreclosure. So the association might, if the owner didn't pay, file a lawsuit, and then you have 45 days to file a response. And then the court, you could dispute the amount due, and you could have a jury trial if you wanted to request that, a bench trial, a motion for, the association could file a motion for summary judgment, or if you don't answer, a default judgment. But you would have had notice of the assessment and notice of the lawsuit because it is already required by Georgia law. And then ultimately, after the court determines whether it is by a judge or by a jury, the judge would hear the amount the association it claims is past due, and the judge or jury would determine what that amount is, whether it was a money judgment or a money judgment in an order for foreclosure. As the speakers talked about, and John mentioned specifically, the statutes, the Condominium Act and the Property Owners Association Act already require that the lien be at least $2,000 in order to foreclose. So the lien total would have to be at least $2,000 to get an order for foreclosure. Once the court enters an order for foreclosure, then there is a whole other process, which is through the sheriff's office. The sheriff has to advertise that the property could be foreclosed on, and then ultimately schedule a sale. So the absolute quickest this process could, that I have seen it, is 6 months. I mean, technically 4 months if everything went precisely by the timeline, but that's highly, highly unusual. Many of these cases linger for years based on the particular judge's docket or the sheriff's load for foreclosure sales. But it is a multi-step process with multi-steps of notice to an owner, and with opportunity for an owner to respond, certainly before this ever happens, or in court, or to resolve it before foreclosure. The association's foreclosure rights are for the condominium associations and associations that have elected to be bound to the Property Owners Association Act. They're only foreclosing subject to the superior liens, so that the mortgage is still there, the first mortgage, and any property taxes due, those actually take priority over the association's lien. And then for common law HOAs, they typically, I have seen one over my many years for a common law HOA that foreclosed because the association would have to pay off the superior liens before they could foreclose. They don't have a statutory right to foreclose. So for common law HOAs, it's even more rare to see a foreclosure. I'll stop for a second and take any questions on that process.
I've got a couple questions. I want to go back to HOAs being in nonprofits.
Yes.
Is that done in every other state? Do they operate under nonprofit law?
Most,
in
not
other-
every state. I have colleagues in Virginia, for example, where the condominiums are not incorporated, and they're not required to be incorporated. They are in Georgia. So there are some states where they are not required to be incorporated, but our statute requires that, and most of the governing documents do that.
Is there an advantage or disadvantage to being in a?
Well, there's an
set up
advantage to
incorporated?
owners because there are rights for requesting a special meeting. There's a structure for and the duties that I mentioned for directors and officers. So there is protection, and there's protection for the volunteer leaders that they're operating rather than individually through the corporation.
And so, and I asked this question earlier, but if an HOA, the association itself, is not following the law outside of the homeowner taking them to court, there's no other process or remedy?
Well, there's no
in Georgia.
there's no government agency that is overseeing and coming in to charge an association with not following a statute. It is owner-driven, and the Georgia Real Estate Commission does require licensing for managers. So, but that's the management, not the association itself for the volunteer leaders. So the processes for an owner are outlined both in the nonprofit code but also in the governing documents. So most of the governing documents provide for this right to mandate a special meeting, and if the owner has, there's a petition requirement. If the owner gets that petition signed by whatever the specified number is, which the nonprofit code was amended also last year to lower that percentage, but if the owners get that percentage and the board doesn't call the meeting after 30 days, the owners can call the meeting themselves. So there is a mechanism for that. If an association is not meeting, owners can act together and make that happen. There's also, most governing documents have a dispute resolution provision. Usually it's in the declaration, and it requires that the board meet with an owner in good faith when an owner has a dispute with the association. So John talked about mediation, arbitration. Most governing documents, if not mediation, arbitration, which I have many clients that actually have a formal dispute resolution process, but most of them have a more general requirement that the parties meet in good faith to try to resolve a dispute. And that's even outside of a required hearing for fines. So we talked about earlier, John was talking about levying fines, and you asked about how does an owner challenge that. The courts require, in order for associations to collect fines, that the association followed the dispute resolution in their governing documents precisely. And they're not going to award these fines unless the process was followed precisely and they are reasonable. And so there already is a requirement for due process for collecting fines in the governing documents that courts are going to require. Consistently, we have seen that in Georgia cases and in other states.
Okay, and then speaking of fines, if it's a public road that the local municipality pays to upkeep,
Yes.
can that HOA fine people for parking on the street, on a public street?
Right. In my professional opinion, no. And we advise associations not to do that because there is a case. There's a Georgia Court of Appeals case from years ago now where a townhome community towed a car from the public street. And the court held that the association did not have jurisdiction over that public street to enforce their parking restriction. So for that reason, and there are a lot of especially older governing documents where there's a prohibition on parking on the street. And my advice is typically, you can always ask the neighbor, because it can be annoying if you're the next door neighbor and there are always cars out on the public street. You can always ask them, certainly if they're impeding the flow of traffic or preventing the school bus or emergency vehicles from getting by, engage the fire department, engage the local police to see if they will help. But otherwise, I think the case law is clear that there's not jurisdiction over that public street.
And since that court ruling, we've never codified that
No.
in state law, correct?
No.
Okay. That's something we need to do. Okay.
Yeah, and I do, that's an example where I say put your tax dollars to work, because they will often help. While they're not enforcing, code enforcement's not helping enforce private covenants, certainly if cars are impeding the flow of traffic and it's impacting safety of the residents or preventing children from going to school, they'll usually help with that.
Okay. All right. Questions from the committee?
You know I have.
All right. Go for it.
Thank you very much.
You're welcome.
And one of the first things that you said was that they have to know that they're being foreclosed on.
Yes.
But I've had hearings for over a year and a half, 2 years. And I guess I have about 18 people at least, because I try to keep a list of folk that have the same complaint. But they were foreclosed on and lost their homes and didn't know about it until they knocked on the door. So they lived in different counties. It wasn't just Fulton or some.
Right.
So I want to know what can they do about that? Can they get their house back if they prove something, or, if they go back to the courts? What
Well,
happens then?
I can't answer that for those. I'd be happy just not to give them specific legal advice, but it would be interesting to see what the course of those 18 cases were, because as I said, by statute, and this is outside of condominium and HOA law, if somebody files a lawsuit against you, we are all entitled to personal service of that lawsuit. So that's not specific to HOA condo law, and you can't foreclose on an HOA condominium lien in Georgia without getting an order from the Superior Court. And so a lawsuit must be filed. We don't have non-judicial foreclosure for HOA condominium liens. It requires an order from the Superior Court. So maybe there's, some different information or other information, but it is a statutory requirement first to send the notice of foreclosure. That's already codified. And second, that you have to file a lawsuit to get an order for foreclosure. And third, that you have to serve the lawsuit to the person. And then, of course, they would continue to be getting notices of, as the case proceeded, the motions, the hearing dates, and then ultimately, if an order was entered, the court would send the order the law firm would send the order, and then the sheriff would be publishing the notice of foreclosure. So it would be, I literally don't know how that could happen.
Let me ask you this: would all that be public record each?
Yes.
Each time they filed.
Well,
something?
not the notice. That would, of course, just go, the initial notice of the notice of foreclosure,
Mm-hmm.
the threat to file the lawsuit would be sent directly to the owner.
Mm-hmm.
And, and if an owner had left the property, it would be sent to the property of record or wherever that person had notified the association to send notices. But that would be private. But otherwise, absolutely, everything from that point would be public record because it would be a lawsuit.
Filed in a court of law.
Correct.
Okay. Go ahead, Senator James.
You said that it's codified in law.
Yes.
Is it different in different counties?
No. In the
It's
state
a
of
state
Georgia,
law.
correct. If you are, if
Because
someone in our state files a lawsuit against anyone, you have to serve the lawsuit. It's the first step in the process.
Okay, I'm familiar because
Yeah.
I had to work with, my son was a marshal.
Right, yes, he
Well,
probably
you know-
served many of them.
Right. And so, I know
Right.
what Fulton County law says.
Right.
But these people, how many people in here know what I'm talking about, have had these problems? See, I've asked them to come today because I know that is not happening. They are being foreclosed on. They are losing their homes. Oh, and they don't know most of the time, like you said, the mailbox. I know that they'll do that in a heartbeat in Fulton County about a mailbox. Amazon kept coming from my neighbor's house and hitting my brick mailbox. I had two at the top. Big mailbox, like $3,000 mailbox, not little bitty. And they kept knocking them down. They wouldn't pay for them. Code enforcement got me, and thank God I don't live on one of the streets off of my street because they are HOAs. I'm on the main street that was there already.
Right.
And so, they couldn't find me, but the neighbors got upset about it. So we need to talk and make sure that we
Yeah.
address this, because you have people sitting out there with their hands up now. I don't think we can recognize you right. But, we need to
Yeah.
do something about it. It's a
yeah.
conflict of what, you're telling us the
Right,
law.
right.
And I
Well,
appreciate that.
Yeah, I'm here to help the committee, and I want to be part of the process.
Okay, thank you very much.
Thank you. Any other questions? No. Okay.
Okay.
Julie,
All right, thank you so much for your time. I really appreciate the opportunity.
Thank you. Okay. So that 10:15 recess, we don't need because that announcement is actually 1:45. You're correct, Raul. In Center Beach. I can admit when I'm wrong. First time ever. Just kidding. Anyway, all right. So I've got for the sign-up sheet to speak. This wasn't a sign-up sheet for roll call. It was to speak. So if I call your name and you don't want to speak, just simply tell me you're waving, or just say you're good. Because I did have 26 sign up, and I don't have much more than that in here, so I can't imagine everybody wants to speak, but you never know. Councilwoman?
Representative,
Oh, yeah. Representative, you want
he's
to?
an attorney,
Yeah, Representative, why don't you come on up first? So,
Terry Cummings.
Representative Cummings, our state rep.
Thank you very much. Good morning, everyone. My name is Terry Cummings. I am a state representative, but I'm here this morning because since 2017, I've been on the board at my Homeowners Association. And I have a little bit of different perspective about things. I was able to sit in, thanks to Senator James, one of her hearings during our session back in March. And some of the things that I heard, like the attorney here, I just never heard before with some of the problems that were going on. But my subdivision is kind of unique. I live in a single-family home, and I serve on the master board. My subdivision also has townhomes. The townhomes have their own board. We also have condos, and the condos have their own board. The interesting thing is that the subdivision now is a little over 20 years, but the condos were built first, and underneath them were commercial units. And this all occurred before I got there. And when the prior speakers, I basically agree with everything that they were saying, but I do think that there is a disconnect with the developers as they're getting towards the end of the sale, and they want to get those homes sold. I know that when I moved in, every single person, we were all told that we would have a guard in a guardhouse, because there's a little guardhouse. And come to find out it was decorative. So we accepted it and moved on, because we were going to have to take over the cost of paying somebody and retrofitting it to accommodate somebody that would be a guard, the toilet and all that kind of stuff. And we decided, don't have the money, keep rolling. So we never did it. But I did notice that developers keep the HOA fees intentionally very low because they want the homes sold. And so by the time the real board takes over, thank God we had somebody at that time that came from a huge subdivision, knew that they were on the temporary board, and they insisted on that reserve study. And that reserve study has basically been our Bible. It justifies when our fees have to go up, what we need to keep up on, because I live in Cobb County. Our subdivision is gated, and I am an attorney, but this is not my area of expertise. But I can say that we have been told by more than one entity that because we're gated, we're responsible for everything within that gate. The curbs, the trash collection, the streets, the retaining pond, and we do have one, and we've accepted that we deal with that, and it's always been like that from the beginning. So for us, the reserve study is everything, making sure that we have enough money in the reserves so that when these things come up, we can take care of it is everything. And of course, like everybody else, we need the HOA fees to be paid. When I first started my participation, I was really the clubhouse person. People make reservations and stuff for the clubhouse. Then I got more involved, and I did notice that when COVID was going on, we didn't raise the fees at all. And so when the townhomes raised the fees, eventually $50, and we have a Facebook page, people got all upset, up in arms. They voted the board off, and the board was a 5-member board, and they had 9 people on the board. Now, if anybody has ever served on the HOA board, it's hard to get in touch with 5 people. Can you imagine trying to get in touch with 9? And those 9 people found out there's a difference between complaining on Facebook and writing letters and having to meet weekly and monthly to do your job. And if you're going to do your job, it is a lot of work. And nobody on the board, at least that I know of, gets paid for it. It takes up a lot of time. You can be held financially responsible, the board can, for your mistakes. And if you don't stay up on top of things, things can go south rather quickly. So obviously this 9-person board became a 5-person board within a matter of months. Then it became a 3-person board. But because the people in the townhomes didn't want to pay any type of fees, anything that happened, they went to the insurance. So they had the insurance paying for everything. And last summer, one of the homes got struck by lightning. So of course that had to be covered. Well, when they went to have the meeting, because the person that knew what they were doing were trying to come back, they wouldn't let him. By the end of the year, they said, we're done, we're off the board, you could have it. So now this person comes back, puts people in place again that want to do the work. And they came to find out that the townhome insurance fee that used to be $7,800 a year was now $30,000 a year. And that's because the prior board did not know what they were doing. They didn't want to pay for anything. So it's just like car insurance, homeowner insurance, anything else you have, You keep filing claims, and that's going to come back around. So that's the other side of the story, I think. You know, anybody can run for the board, but you have to have some sense that your actions are being for the betterment of the neighborhood, even if you don't like it, because that's your job as a board member. So now, everybody in the townhome, doesn't affect Terry, doesn't affect me, because I live in the single-family homes. It was only impacting the townhomes, that they were going to have to pay a $3,000 or $4,000 special assessment because of the prior board's mistake. But this individual negotiated all over the place to get the price down. Still wasn't able to get it to where it used to be, but it certainly isn't $30,000. So I want people to keep in mind, and that's just one story of throwing out the baby with the bathwater because people don't like things. One of the things when I was sitting, when I had the opportunity to sit, was in the prior hearing that you had in March, was a complaint about the assessment fees. Nobody wants to pay a high fee, but nobody wants when you move into an HOA subdivision, you're attracted by the beauty of the neighborhood and by the amenities. There's a cost for that. It's not free. And I think a lot of people think that once they get in, those fees are supposed to stay a certain way when everything has gone up. Every vendor has gone up in price, but somehow the HOA board is supposed to keep the prices down the same. And it's just not possible. Now, are there problems? Absolutely. But I caution to, like I said, run to conclusions that it's all on these volunteer board members. Now, some of them, they're out there doing things that I have just never even fathomed. But that's not the majority of the boards. The condos had a totally different problem. The developer, who eventually sold to another developer, when they were closing, the president at the time was only 27 condos. They got the president to sign away the rights of the entire condo, the people living in the condos, so that they don't get any reimbursement from the commercial units downstairs. Signed it away. By the time the other members found out, the gentleman had passed away. His wife had moved out. She didn't have any money. They tried for years to sue, but that means that all 27 members had to come up with an exorbitant amount to pay the attorney. Unfortunately, that never happened, and now they're stuck with it. When that developer, what I would like to see is something to prevent that from happening again. One person, regardless of your title, should not be able to sign away the rights of an entire community. And I don't know what they told this gentleman. We'll never know because he's deceased. I don't think that he realized what he was doing, but it was a deal with the developer, the owner of the commercial property, which is somebody different, and then that president. And that's been an unfortunate situation because these condo owners have been paying this and dealing with this ever since. And it really should not have happened. The other thing unique about our subdivision is that the Masters Association, which I serve on, we pay the water for those commercial units. And we've been fighting for years trying to get separated from it and to make them pay their bill. So we do have money, and we're getting ready to file a lawsuit to try to resolve it because years of going back and forth. But these are just some of the things that I don't think people think about. We also pay the water bill for the townhomes, and they have to go after them. And it's all the way the system was created by the developer. And Cobb County, approved it. And of course, when you're buying a house, I didn't read the covenants going in, but that information is not even in the covenants. You find out after the fact who's paying what and who's responsible for what. So my takeaway is being on the board is a big responsibility. It's a lot of work. I do it because I enjoy it. I pretty much got involved a little bit more because our attorneys weren't really being aggressive enough, go figure, to go after homeowners. And I noticed that with one situation, we had a judgment, we had a garnishment, and then they went back and did a consent decree with the homeowner because they couldn't find her address. Well, I used to work for the feds, and federal employees are probably the easiest people to find and locate. You just have to look where the employment is and then to get their fees. And so that's how I got involved, because while some people are too aggressive, some people aren't aggressive enough. And that's been my experience, and now we work well together to make sure. But we've never, we haven't foreclosed on anybody. We have somebody that owes $18,000 now. They have a renter in there. Can't find the person. We have judgment, garnishments, can never get the money. And it's unfair to every other resident that lives in those subdivisions that somehow come up with that money. You know, nobody wants to pay it, but nobody wants to walk out their home and see the flowers aren't blooming, or you have, you know, some kind of damage, or the gates aren't working. It's always something. So that's what I kind of hope that people keep it in mind. It's definitely, as the previous speakers have said, it's definitely two sides to the situation. You have people that are obviously abusive that need to be dealt with. I think personally that if your fees go up too much, it's up to you to petition your, because you do have rights, and you can't overrule the board, and that should be in your covenants. And you go knock on those doors. But if your neighbors are not interested in appealing and going after it, I don't think it's right to come to the legislature and ask us to do something because you couldn't get your neighbors to do it. And so I think that communication is key. I think keeping your neighbors, trust and believe the neighbors, the people that live in the townhomes, they pay attention now, because when they didn't, and they just let a group of 9 people come in and say, okay, nobody has to, our rent's not going up, you don't have to really pay for anything, they're paying a big price for that now. And that's, thank you.
Can I ask you one?
Yes.
I'd like to know, first of all, we're talking about predatory HOAs and COAs and.
Right, my concern is just the baby gets thrown out with the bathwater, and it ends up hurting those HOAs that do bend over backwards to do, you know, everything right.
Okay, my question though is, did that replaced board member have to live in the subdivision?
Yes, the way our covenants are drawn, every board member has to live in their particular area. So, for example, I'm on the master board. We basically deal with the common amenities, the gates, the roads, the clubhouse, the pool. Mm-hmm. I cannot even attend a townhome board meeting because I don't live in the townhomes. I cannot attend a condo board meeting unless they, you know, I ask and they say you can come, but I don't have an automatic right to. But anybody that lives in the subdivision can attend a master, because everybody that lives in the subdivision, regardless of where you live, you pay into the master. And we do come together as far as negotiation with the community management. We all have the same company, even though the townhomes at one point they tried to, you know, wiggle out. We try to keep the same vendors, because when we come together, you can get a better price. Mm-hmm. But they don't necessarily have to.
Thank you. And you've had 2 people in our other meeting that came from not your particular.
Correct. The attorney who wasn't able to make it today, and ours is community management associates, and they're excellent.
Thank you very much.
You're welcome.
Thank you, Representative Cummings. All right, next up we got Councilwoman Linda Pritchett from South Fulton.
Good morning, everyone. Thank you so much, Senator Brass, for putting this together. This is something that is extremely important. Again, I am Councilwoman Linda Pritchett from the great city of South Fulton. I have some of my residents, constituents that are here today. I have had a positive experience on serving on my HOA board as vice president. We did a lot of great work. We created the board from the declarant current board, and I do agree with a lot of the information that was shared today. It is a labor of love. Somebody has to do it, somebody has to care, and it's a lot of hard work. But I would like to speak to, starting with, HOAs should be about preserving values, uniformity, conformity, sharing the cost of amenities, common areas, and even safety. And what I like that the attorney who referred to board members as volunteer leaders. However, I believe in certain instances in my district that serving on the board or the board has become something about control and not necessarily the shared and common interests of the residents. Using the board's authority to weaponize residents who, the reason why thank you. I believe that the reason that you buy homes in these type of communities, in HOA communities, is because you want an improved quality of life. You want to have the useful, peaceful enjoyment of your property. But what I've seen happen is most boards refuse to work with people, to meet with residents when there are issues. Thank you for the applause, but let's hold it so we can move along. One of the biggest problems is the lack of training of board members. I do agree that people serve, some do have a financial interest. I believe that the financial interest that the board hold and the power of directing those funds, that cannot be overlooked. That is a big issue. There are people in this room that have served on boards that have had control of over $1 million in collected fees and funds. And many times those funds are not used for the benefit of the community. I see that there is no accountability on the part of an HOA who controls and directs the entire process. And the process is unbalanced. So you have lack of training, then the board members have a lack of understanding of covenants, which can be very legal and technical. I'm a certified paralegal of over 20 years. In my head, I think I'm an attorney, but I'm not. But what I am is I am a lawmaker and a policymaker. So serving on boards is not something that you can just easily do based on, I don't like the color of your house, I don't like this or that. Not following the Georgia Nonprofit Association rules is a significant issue. We have HOAs that do not have quarterly meetings or keep minutes, that do not allow residents to vote for new board members, alleging that a quorum is not met. There are 4 people in this room that live and I'll say it, at Oakley Township. And for 3 years, they have been held hostage by a president that does not live in the community. Every time that they get together to have what they call for a meeting, he claims that there is not a quorum. Hundreds of people show up, and yet the same board remains. Then there's another individual that lives in Walton Hills, where you have a 2-member board, which is the husband and wife. This is not funny, because it is not funny because this resident is being terrorized by 2 people that decide to dictate what goes on, what they want to and don't want to do. So there's also, from what was shared today, there is a difference between running the daily operations of an HOA, which management companies do, and the legal authority to regulate HOAs, which I believe that at this point it seems ambiguous, but to me it's extremely clear. HOAs are nonprofit organizations under the purview of the Secretary of State. And what I see is that the Secretary of State does not regulate their activities, and I would like to see them involved in a regulation process, whether it be administrative. I do not believe that the solution to HOA issues needs to go to the courts. I do believe that as a corporation and their structure, that they should follow the law as any other nonprofit should follow. I also believe, to Senator Beach's comments about HOA boards can work with cities and code enforcement on specific items. So as an example, Representative Cummings mentioned when the builders are leaving and they have all these different phases and they prolong topping off the roads and amenities and things until they're about like 80% built. What's happened in about 4 of my communities, and including the subdivision that I live in, is that the developer leaves, even though there was a bond, somebody just forgets, signs off on the bond, it's released, the roads are not topped off, and then the cities, we have to go into our funding to make sure that the roads are paved, when this is something that's a financial responsibility of the builder. So in closing, I want to say this. When you look back to the HOAs and how they're treating people, when you look at the damages and what the HOAs are claiming, sometimes they say, hey, you have a broken mailbox. Hey, your house needs power washing. Your grass is not cut. So what do they do to mitigate these damages, right? What is the harm that they are claiming that is so egregious that would come or rise to the threshold of wanting to take someone to court and even take someone's house? That makes no sense. The seniors are so vulnerable, because I have a senior in one of my communities who built a brand new house, and there was problems with the piping. The house flooded out. She had to be placed in a hotel. While she was living in the hotel, there was all types of equipment from all the construction. She lived in a hotel for an entire year due to the bad craftsmanship of the builder. However, while she was living in the hotel and had all this equipment in her driveway, the HOA decided to fine her. She's an elderly person and a widow. They fined her to the point in excess of $5,000 because of the equipment that remained at her home while these things were happening. So when she went back to her home, she faced foreclosure. This is an abuse. And so the good news that I would like to say is I believe that there's something that can be done to make sure that people are not financially harmed, that people are not taken advantage of, and on the flip side, that we can help to empower people that serve on HOA boards with best practices, with education, so that they would understand Robert's Rules of Order. When I served as vice president, I mentioned that we should purchase Robert Rules of Order, and one of my board members said, I don't know who Robert is, but he need to mind his business. I am not lying to you. So even to the extent that in my city, we have boards and commissions. We have a planning and zoning board, and we have one of the members here today. And because of some of the decisions that were made based on personal knowledge and not understanding parliamentary procedure, I created a resolution requiring that they have this training. So what I will be doing in the city of South Fulton is I would like to create an HOA task force and advisory committee so that we can look at all these different scenarios and that we can help bring recommendations and information, in addition to holding workshops with the HOA Alliance, which is an educational arm that we use, so that we can bring some positive outcomes to this, but also that we can work together with the state to try to look at different laws that can help. Also, I was talking to Senator Brass before this hearing, and I have been working with Senator James and Senator Halpern to look at also residency requirements for the board. There are a lot of little quick fixes that will nip a lot of things in the bud, and I'm here to support this type of committee and these type of actions and everyone who's here in this room. And I thank you again for giving me the opportunity to present this information to you today.
Thank you, Councilwoman Pritchett. All right, next up, LaTanya Hollis. I believe you presented last week, so
I
do you have some
did.
new information for us?
I do. Good morning, esteemed members of the Senate Rules Subcommittee. Thank you for your service, and thank you for your increasing the visibility surrounding this topic for your Georgia constituents. I'm coming at this at a different perspective. I stand before you today to represent myself in my own capacity, not on behalf of any employer or group or firm, and to discuss a critical issue that impacts homeowners across the great state of Georgia that a lot of you may not be aware. Specifically, an increasing trend of homeowners association management companies applying additional fees to payments and the consequences it has for those homeowners. Recently, my HOA was found to not accept debit card payments for the payment of HOA dues and was applying a 4% surcharge on credit card payments to accept that payment. This matter was reported to the issuer of my credit card company. The HOA's management company's bank was contacted, and the HOA management company began accepting debit card payments, but began applying a 4% processing fee to accept that payment. This fee is not applied if I was to walk in and make my payment via a check or cash. These added fees increase the total cost of annual dues, placing an unnecessary financial burden on homeowners. The Durbin Amendment, enacted as part of the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010, limits the fees that financial institutions can charge retailers for debit card transactions. Specifically, Regulation 2 restricts debit card interchange fees to ensure that retailers, including small businesses, are not burdened by excessive fees that are ultimately passed on consumers. The purpose of this amendment is to lower transaction costs for retailers and ensure more affordable and accessible payment methods for consumers. Many HOA management companies have begun applying surcharges on top of regular payments only when homeowners use a debit or credit card to make their payments. These fees are not applied when checks or cash are utilized and paid in the management company's office to accept payments. This increased cost can be considered a form of penalty for using modern, convenient payment methods. Some of these actions, especially refusal to accept debit cards, create barriers for homeowners trying to make timely payments and are inconsistent with the consumer protection goals of the Durbin Amendment. My personal example was I was traveling out of the country, was trying to make my payment using a debit card. My payment was refused. By the time I returned to the country and was able to make my payment, there was over $700 in late fees that was added because I always pay using cash. I don't use credit. Under Visa and MasterCard rules, merchants are not allowed to charge any additional fee beyond the stated published transaction amount unless explicitly allowed by law. Under MasterCard's rules, merchants must provide MasterCard and their acquirer with at least 30 days written notice before implementing a surcharge, and merchants must disclose their surcharge practice. In this case, the HOA management company must disclose their surcharging practices at the point of sale, in this case, on the website where they accept payments. The surcharge amount must be included in the transaction amount. They are now excluding that amount, so when you make your payment, you are not even aware that you paid a surcharge on top of your HOA dues, and it must be disclosed separately on the receipt. So, for example, if an HOA management company, if homeowners' HOA dues are $2,000 a year, the HOA management company applies a 4% surcharge at $80 a year per homeowner, times 300 homes, for example, in our community. That HOA management company is collecting an additional $24,000 in HOA fees on the backs of homeowners because they are paying with a card versus cash or check. Visa surcharge rule number 6948, permits merchants to impose a surcharge of up to 3%, but only on credit card transactions. This fee cannot be applied to debit card transactions. However, this rule has been misapplied by many HOA management companies to debit cards, which contravenes Visa's rules and raises serious concerns about consumer rights and transparency. There are some key problems here. Homeowners are often unaware of additional fees until they attempt to make payments, leading to unexpected costs. These extra fees disproportionately affect those who may not have other payment options or may not be able to visit an in-office in person to avoid the fee. In my case, not having a credit card in my possession to be able to execute that payment. By refusing certain payment methods and imposing penalties on certain payments methods, such as credit cards, homeowners association management companies and HOAs create additional obstacles for homeowners trying to make on-time payments, which can lead to late fees, which can lead to foreclosure. My plea to the subcommittee is to please consider, as you structure this bill, to please investigate the practice of homeowners management companies charging surcharges on top of homeowners payments and refusing debit card payments, particularly in light of federal protections such as the Durbin Amendment. Please clarify legislation to ensure that consumer protection laws, such as Regulation 2, apply to HOAs and other organizations that manage payments for homeowners. And to please encourage accountability by ensuring that credit and debit card rules are followed correctly to avoid unfair penalties to homeowners. And finally, please create oversight mechanisms to ensure compliance with these rules at the state and local levels. My final appeal is that homeowners across the country are facing increased financial burdens due to additional barriers that are created by homeowners associations and their management companies. And it is crucial that we address this issue to ensure that all homeowners are presented with fair and transparent means to submit their homeowner association payments and dues. Thank you for your time and attention. That's all I have.
Thank you. Okay, next up, we've got, I don't know if this says Kathy Kelly or Kay Key or Kathy Kelly. Come on up.
Thank you so much for allowing us to come in and discuss this. So we're a little bit different. We are a self-managed HOA. 8 years ago, we decided to go the self-managed route. And at first, it started out great. We saved money, and it was something that we all kind of pitched in. But now we're 8 years into it, and we have had an issue with one person who controls basically the books, everything, and we can't get them off the board, and it has become a hostile situation. It's one of these where we have cameras now around, and we're a small community. We're in Cobb County. We're Stonewall. We're near Vinings. We have a flock camera. We're not gated. We have a flock camera. We have cameras at our pool. We have cameras in our park. These cameras are being utilized to watch, to record, and to be fined by. And so we are really kind of struggling with how do we go back to having a management company? We're kind of, some of us are like, well, was it better with a management company? One of the things that I think, and I really appreciate the fact that it is a volunteer position, but I love what you said, because it is also a position of power and also a position of bringing in a community together. One of the things that I find so hard is, yes, we have neighbors who don't want to participate. Why? Why are we not reaching out to our neighbors to find out, why don't you want to participate? Why don't you want to come out and plant flowers on a Saturday? Why don't you want to come out and be a part of the community? A lot of it is because they're fearful of retribution. We've had a lot of finding. Right now, we have more houses on the market than we've ever had. We have Open Door coming in and buying homes at 30% below market that we've never had. And we are in a growing part of Atlanta. And a lot of that is because we have an HOA that overreaches. We have parking issues. We were assigned 2 parking spots when we bought our units. Excuse me, I'm going to call them homes. We've been drilled units into our heads, yet we're homes. We own our homes. So when we bought our home, we have 2 units, 2 parking spots. We now have stickers, but we don't have rights to the 2 units, to the 2 spots, if we don't have 2 cars. We cannot loan out our space to anybody else. We cannot have somebody come in and use our space. They have to be registered. They have to, if we're gone for longer than 2 or 3 weeks, we have to notify somebody or our car is considered abandoned. So we do not have the freedom that we bought when we bought our home, excuse me, that unit's in my head. And so, I don't know what the resolution is on being self-managed. I just know that, this is my home. I didn't come in here to live in an apartment. I don't live in an apartment. We have a roommate situation that we had an instance, my neighbor, she just sold. She had a boyfriend, met him, going great. He was there at her home for 30 days straight. She got fined $25 a day because after 30 days, you were considered an occupant. So they said, basically, you have to put him as an occupant in your home as a roommate and pay the roommate fees, or he's going to be fined $25 a day for every time his car comes in. And basically, they tracked it on Flock. So Flock, which is supposed to be for our security, is not for our security. It is watching us. It is telling us we have to let them know if somebody is staying in our home for a certain amount of time. And I've asked, why do you have to know who's in my home? Right. And they're like, well, it's for safety. Well, let me worry about my safety. Okay, you worry about yours. So I just think that there's an overreach. There is an overreach on a lot of HOA boards. I mean, we are a community. We're 100 homes. You know what? I get along with 95% of the people that I live around. The board is handpicked. The one person who's been on the board, we have 3-year terms. There's no limit. She's been there 8 years now. She handpicks the people that she wants to run. And so last year we had 2 positions. We tried to get 2 people on the board. They did a smear campaign, calling people, telling that people were not ethical that were trying to get on the board. I mean, there's just got to be some limit to what a board can and cannot do. And I do think there should be a limit to the amount of times that somebody serves on a board contiguously. Take 3 years off and then come back. But let other voices come in. And our community is over 40 years old. Our governing documents are 40 years old from the 1970s. This last year, we put together a committee to go through those documents to upgrade them. We're not the 1970s anymore. Single families do not look like single families back then. And we are struggling because the board has said they had to be approved by the board before we can even present them to the community. And that's backwards. I think the community should be able to look at the changes that we're proposing for the governing documents before the board, because if the board does not want us to present them, they can vote against us presenting these to the community. Now, being Irish as I am, I will go and do it anyway. So, because I think that we all have a right to understand and to create create our community around us. And we love our home, but people are moving out because they feel like they don't have any kind of autonomy in their home. We have to have white curtains. We can't plant plants. They have to be in pot. I mean, the rules, and we get fined. I mean, $25 a day adds up. It adds up. So my neighbor who finally moved out, she had over $1,000 for a month of parking on her HOA. She got an attorney. Then she was not able to use the pool. She was not able to come to the HOA meetings. She was not able to participate because she had hired an attorney to come in and represent her. So she still was paying her HOA fees, but she wasn't paying the fines. But all of her rights were taken away. She moved. I lost a great neighbor, but we're losing value in our homes because of it. So whatever the committee can do to help balance the authority given to the HOA board, which we elect, they're here to serve us, not the other way around. And they're there to manage our money, to manage our finances, to manage the growth of the community, not to manage our personal lives and what goes inside of our house. Right. So that's kind of what I wanted to put out there and just say thank you very much for your time.
Thank you very much. Next up, Christina Potts. Are you still here?
I am.
All right. The mic is yours.
All right. I appreciate it. Thank you so much for listening to me testify this morning, and thank you, committee, for taking the time to consider homeowners, opinions. I come to you today, I was on a board for a year. We came from a community in Noonan, Georgia. That's where I'm from, right? Not too far. And that homeowners association came into the board after 15 years of declarant ownership of the HOA, managing of the HOA. So basically, that declarant was passed down from 3 to 4 different declarants because the builder, over the years, because of the house in recession, as you were saying, they had different declarants. And what I witnessed when coming into the board as an HOA member was something really disheartening. I came into books that were negative, $365,000 in the hole. I saw that there was no accountability from the declarant to actually show what those books were written off for, negative. And they basically almost like disappeared into thin air. So after serving on the board and seeing the large books, the negative balance, after 2 months of being on the board, I was forced basically to seek legal representation because I was abided by other members of the board and management companies to try to unsee what I saw and pretend that it didn't exist. So I saw late fees not being assessed. What I mean by that is late fees not being given to owners so they were aware that they were even late. I saw fees accumulating on homeowners, them not being notified of this. And I don't know if there's a law that they are supposed to receive notification. And I'm not sure when they receive, how it is proven that a homeowner actually did receive notification. By me speaking up, I became a target, as you probably a lot of people in this room are aware of. So if you try to be trustworthy and you try to be honest and you try to do your duty as a board member, you will be attacked, unfortunately. It first started with parking. Just some arbitrary charge of $50 a day because I was parking partly a little off of my driveway. But, that was rectified by legal means, unfortunately, that I had to front from my own pocket. And it continued from there. Where now I could say we're talking about grass and trees and shrubbery, $25 a day for that branch, $25 a day for that branch. And if you're a homeowner and you do want to go the legal course of action, which is go ahead and meet with the board members and say, hey, this is incorrect. What you're doing is not fair. It's not just. Like you pointed out, Senator Brass, that, you are meeting with the people who are fining you. You are meeting with the people on the board who are literally borderline harassing you. And what I mean by that, in my case, my son, my children outside, I have HOA board members coming by, walking by, taking pictures during broad daylight. I feel trapped. I feel trapped in my own residence. And it's very emotional because, as an American, what is an American dream? You work hard. You work hard for your home, for your place to live, to have your family, to have a peace of mind, to be safe. And it's just gotten out of control. And when I was on the board, you start saying, well, what is this? What is the purpose of this? It's kind of like I hate to say it, but there is something systemically wrong with this practice. And I started looking at the history, and I realized why HOAs were formed to begin with. It was in 1964 in California. It was to run Jewish people out of communities, black people out of communities, Asian people out of communities. And I can't say that that's not happening today. What I see is people getting on the board, and it's like bullying at the finest. And then they realize that there's a money aspect to it. And then once somebody gets a taste of the candy, they just want more. So what I just overall, I'm very happy that this is a bipartisan committee. And I thank you, and I thank God that you guys are coming together to listen to your constituents. I really do. It's a beautiful thing. It really is. Because I shouldn't be fined for a twig. I should not be fined for a flower. And I wish I could have, I could actually put my pictures here so everyone could see. Okay? I shouldn't be fined because I speak up and say, what you're doing is wrong. What you're doing is unethical. How can we make this better? So I do think the way we can make it better, which I do see, is regulation, oversight of the HOAs. Unfortunately, we kind of know it. We know it's like a wild, wild west. It really is a wild, wild west. And, everyone wants to put their hands in the pot. Everyone wants to get the money. Everyone is after the money. But, the homeowners, when they work their backs off just to own a home, this is just the most un-American thing. Now, I understand the developer coming in and wanting to have uniformity, conformity, before they sell the homes. It makes sense to a certain extent. I see, because I went through that process, I know that there were some unfair practices when we went through different declarants, kind of what Ms. Jones was talking, Senator Jones was talking. I saw firsthand account where homeowners were told that they were going to have amenities provided to them. Pools, clubhouse, and they were not even annexed in to the community. Okay? So they were not, they were told lies. They were lied to. There's no way to go around it. And then after, the board, who is from my community, had to work hard to try to get those homes annexed in because they were told a lie. I mean, how awful is that? And the thing is most hardworking people say, why do people not show up? Well, we're in America. You got to work 40 hours a week, 60 hours, 80 hours. You got your kids, you got your car payment. You don't have time. We don't have time. It is a luxury for me to be here today. It is a luxury for me to be able to talk in front of you. I know multiple residents who are not able to because they have to be at work right now. And I'll give you an example. One thing with the management companies that I also see, and somebody mentioned CMA, and I've had the privilege of working with CMA and unfortunately seeing some of the practices that they do. And Beacon Management. So these companies, they've been in business for 11 years, 12 years, CMA a little longer, but we're talking multi-billion-dollar companies. And what they like to do is find people. Your bush is out of compliance. Your bush is out of compliance. Why don't you hire a landscaper? Oh, you're not hiring a landscaper? Okay, guess what? We got our landscaper for you. They'll hire their landscaper, their quote-unquote subcontract company that is actually part of their company, and then charge you for 30 minutes. I had one neighbor, 30 minutes to treat his yard. And he videotaped, excuse me, what weeds are you going to treat? The serviceman said, well, you really don't have any weeds, so I don't know what I'm going to do, Well, went ahead and treated his yard for 30 minutes of work, $550. Okay. So there is a business here, but because there's no regulations, it's gotten a little out of control. And we can't allow this to steal the American dream for people. We have homeowners who are saying they're losing value in their property. That's just disheartening, And there's no really place for people to run away from this because 85% of communities that are being built this way right now. So there's no exit strategy for a lot of homeowners. They can't just leave. There's nowhere to go to. They're backed in a corner. And so I pray that we can have some legislation to stop the Wild Wild West, to have control. A perfect example is most residents don't have the means to pay $5,000 to go to court? I mean, that's what we're talking about, $5,000. Even a letter to stop and desist is, you're looking at $750, you know? So I feel like the boards and the management companies somehow, what I've experienced, let me just go back. When I became on the board, the management company kind of guided the board. And they guided the board in a way that was not fair and unjust for enforcement. So I do feel like there could be requirement teaching. You know, Robert's Rules is just a good one. You know, just some basic outlining of their fiduciary duties and understanding the law and the consequences. But they have to be enforced, because if nothing's enforced, then nothing's going to change. And I think a lot of these management companies and the boards who are running astray have realized that there is no enforcement. They realize there's no consequences to their actions. No consequences to their actions. So I appreciate it, and I know I went a little everywhere, but I thank you both for taking the time, and the whole committee for listening to me, and hopefully we can all work together and implement some change.
Thank you very much.
You're welcome. Thank you.
Ask her for that in writing.
We've got it on.
On tape.
Yes, on tape. So, all right. So, look, y'all, we were supposed to adjourn at 11. It's 11:30. I got 21 more people on this list. So, from now on, we're going to do 1 minute, because I want everybody to be heard that wants to be heard. And I've got to leave myself at 11:45. So if you want me to hear it, you better hurry. All right, so let's get rolling. Carolina.
We're all from the same community.
Okay, so y'all good? All right, Valerie, Steeple, same group. Paula, same.
No. I was signed up by mistake. I thought it was wrong.
Gotcha. All right, well, we will mark you present. All right, is this Vlad? Same group? You good? Hey, we don't have so many. All right, Yvonne, same group? You want, come on. Together. What's your name? Geraldine. All right, I got y'all both. Y'all got 2 minutes.
Okay. So we're from Oakley Township in the wonderful city of South Fulton. Oakley Township needs your help. We are being held hostage. That's really the only way to put it. We have a problem with the board. I myself have been was fined for $500. I've invested also the money that was designated for my paint for my house in litigation. There has to be another process for residents to go through when there's an issue with the board. And litigation is too expensive, whether you're doing it individually or collectively as a community. My concern is for the last 3 annual meetings, it has been held during the week, during work hours. And that is intentionally, in my opinion, intentionally placed there to suppress making quorum. We have not made quorum since this board was installed, and that has been by design. Currently, we have some things that are going on in the community, the Georgia DOT, Department of Transportation, I believe. They're working on a bridge in our community that was installed in 1961. It's up for repair. Our board is currently fighting the DOT to get more money for the property that they need to complete this project. It is a $3.8 million project that the community is paying nothing for at all. This is what we're talking about our board is doing. Our board, we're getting a new fire station. Our board sent out a petition to our community to block the installation of a new fire station. We don't have a fire station within 5 to 6 minutes of where we are. Okay, they are blocking that. For what reason, I don't know. I think the board is insane, I'll be honest with you, okay? The board sues people for paint on their house, litigation for paint, litigation for solar panels in the age of climate change. It makes no sense. Their decisions are capricious. Their decisions are punitive. Their decisions are inconsistent. Do you want to speak?
Okay. When she talked about the solar panels, a few years ago, a company came and offered to put panels on my house. Of course, you know the process. You get the panels free and you pay for the service. I was denied. And I asked them, I said, why did you deny me? Oh, you can see the panels from the street. Well, solar panels can be seen from the street no matter where you live. And in a time of, like you said, climate change, and people are going more towards solar panels, I don't think the previous board allowed it because one of the board members has panels on his home. They sued him and tried to make him take his panels down. He won his case so he could keep his panels, but they've been denying everybody else solar panels. Also, like she said, they have meetings in 2022 or 2023. We had people that stood at our clubhouse and collected proxies. We get to the meeting, we had enough proxies in order to have a quorum. All of a sudden he says, oh, those are the wrong form, you're gonna have form we give you. But the year that he got on the board, the previous year, 2 years before that, he went around to people's houses and got their proxies. And it wasn't on a particular form. It was a form that he had. So those are the kind of problems we're having in our subdivision. He's arrogant, he's passive aggressive, and he has he's controlling.
Well, we can't let mean people, but
and he doesn't live there.
Yeah.
That's the next thing. He lives in Snellville.
Okay.
We're in the city of South Fulton. So that's another issue. And he also shot up the community a few years ago.
Okay. All right. Next up, Christine Bob. Bobo. Sorry.
I think I drew the short straw. Nobody else from the neighborhood could come. But I appreciate y'all, giving people the opportunity to let you know what's going on with some of these HOAs. And our particular community is a little bit different than some of these. We've been around for over 30 years. It was formed, I think, back in 1979. So we're still operating under an old HOA regulation from 1979. I've lived there about 30 years. There's a lot of residents that have been there longer than that. There's about 350 homes in there. We are one of those situations you referred to, Mr. Brass, that has a problem with a dam, and there's some state regulations that come into play with that. So, but that's pretty much been dropped in our lap, and so we as the residents have been burdened with trying to mitigate that situation. With that has come a lot of animosity between people that live in the neighborhood. HOA members have made decisions that they say we are not privy to take any vote for. So according to our covenants, and that's the thing about the covenants on these HOAs, they write them in such a way that no one can understand them. Not even board members. And when you not only have the covenants, you have bylaws, and then you not only have to go by the bylaws, but then you have to go by corporate law. So you as a resident, if you're trying to discern if you have the right to vote on something, this is what you would have to read. So under our Article 4.
All right, be brief on this because
Yes.
we're running out of time.
Yes. So it says that a Class member should be entitled to vote. However, it does say then, Class B membership shall terminate and cease to exist as herein provided. It's confusing whether the Class A member is allowed to vote for any proposals or changes, for any special assessments, anything of that nature. So basically, we've all gotten a letter. We have to pay $29,000 for the HOA to fix this dam.
Yeah.
And this is an $8.9 to $8.6 million loan we never got to vote on. We don't know what the terms are on this loan. I've got neighbors that are probably going to go into foreclosure over this because that extra money, even if they're providing me a payment plan, for a lot of these people, we have veterans, retirees, people on Social Security, families. They can't afford an extra $250 right now. That's a 20-year loan, $250, you've got $51,000 by the time that loan is due.
Okay.
That's a car.
I'm aware of your situation, and we're
And this
gonna-
is just showing how an HOA is able to just pass things through by telling you that you don't have that right in your covenants, and you don't know until you hire an attorney yourself. But they don't want you to do that.
Okay, and we're gonna talk further. If anybody that I have to cut off short, don't worry. I'm gonna listen to you. Just not today. All right. Next up, Mo Thrash. Are you still with us? I think Mo left. Patricia Wise. Are you still with us? Would you like to speak?
That's okay. I will be brief because that's just the military in me. So I'll take.
We'll say it in the microphone, or nobody will hear you.
My name is Patricia Wise. I'm a member of also Oakley Township HOA, and Linda does a great job. We live in a community that is taken over by the HOA board. The member doesn't live in the community, so that's one of the things that we address with our council person. Even if the covenants say that the member should own a unit, which is a homestead. But the three things that I have is the foreclosure. I agree with everybody that mentioned that in the session here. How can you possibly tell me you're going to take my home that I've worked so hard for because I didn't mow the grass, whatever reason? Many of us are here to pay our bills. We're here to pay the HOA dues. But a lot of people, I think I can agree with that we have major issues that have to be addressed. We can't overlook at this. I've been here, last year? I've been sitting here for last year. It's got to get done. It has to get done. You got, especially the elderly. They're preying on the elderly. Now, I got enough gumption to attack. I was a spokesperson for one of the lawsuits that was in our community. Unfortunately, it didn't go the way we wished it did, even though we knew it should have. But that's all another thing that I'm not even going to burden with you. We need reform. We need legislation. We need the law to change to represent the communities, not the attorneys, not the association management company. I'm a real estate agent. I know the codes. I know the bylaws. I done did all of it, but our hands are tied. We need somebody to look out for the homeowners.
Okay, thank you very much. Let's see, next up, Crystal.
That's okay. 3 members have.
You good? Okay. Cassandra Sappington.
Good afternoon, Senator Brass. I want to thank you for leading this charge. It couldn't have come at a perfect time for me, and I'm going to try to keep my composure, but basically, I relocated to Atlanta 7 years ago for a new way of life. Widow, mother of 3, and I helped my daughter with my granddaughter. We bought a foreclosed home with the bank that ultimately had a lot of builder defects, etc. Moving fast forward, I was having mold and water issue going under my foundation, and created a rodent infestation that was identified over the summer, and finally found someone that was willing to work with me, and it was affordable. And I admit I missed a step by getting the board approval first because it was behind my house and under the deck. Long story short, I was notified. I submitted the request online. I worked with the city of Atlanta. They were very gracious. They helped me through the planning process, got the proper permits. But in the midst of all of this, there was a dispute between our homeowners association and a property management company where the property management company terminated the contract. The board to this day never communicated with us at the end of July that contract was terminated. So I was essentially submitting updates to a black hole portal, and it wasn't getting back to the board. Fast forward, I get a cease and desist in August saying that they still didn't have what they needed. And I'm like, how did this become a legal issue? Never got a hearing, even though I requested one, never got due process. So I reached out to Legal Shield, a service, anybody familiar with that? They wrote a letter just to say, hey, City of Atlanta said they'll be done with the permit review around 9/15, September 15th. We just need a little more time. Well, with the Labor Day holiday, all the plans were due. They finished and issued a permit on September 19th. So I loaded it to the portable. In the interim, I was still sending updates to the person at the property management company assigned to my case, not knowing that that relationship had been terminated. I get a letter saying, oh, by the way, we decided not to, and this is after I get the permit and provide it. We decided not to honor the extension that the attorney asked for, and we essentially started fining you $500 per day back since September the 1st. And it's $500 a day back since September the 1st, and you also owe the attorney fees. And I'm like, how did we even get here? I'm dealing with the property management company. How did we get here? So desperate for answers, I started doing research. I reached out to a former board president because, again, the current members, no one wants to talk to me. I don't even know who to talk to because you always deal with the property management company. And I walked him through everything. He said, you got a good case. Oh, and I forgot to mention the property management company, I got notification from them on August the 1st that my code violation was closed. I'm assuming that was after I submitted everything showing that I was working with the city and just everything. So right now, I've been calling to get legal support and advice.
You're at 3 minutes.
I know, I'm sorry.
That's okay.
But the minimum is like $5,000 retainer fee just to get an injunction so that these people can stop harassing me. My kids are scared to go outside. They're circling, taking pictures of my house and everything. So I'm at a standstill. We definitely need some help. Homeowners like me are being bullied and harassed. And it's just not fair, and we really need some help.
Okay,
Senator.
thank you very much.
Thank you.
All right. Next up, Nick Cruz. Nick, you still with us?
Good afternoon, Senator Brass. My name is Noreen Cave, and this is Nikki. We're here together representing the Landmark
Nikki
condominiums
Cruz, okay.
downtown.
Okay.
And Senator Sims, she has ownership in the property as well.
Correct.
I've
She
been there
tells
over
me.
35 years. Specifically, no one to hear spoke about the Airbnb issues that we're having. It's been a nightmare. The building has literally no more security. It's turned into an in and out, I won't say hotel, but a motel environment. There's been murders, deaths. And someone mentioned the fire department. We had a fire in January. And by the grace of God, there was a fire department who happened to be directly across the street at the time. So that was the timing of God that allowed him to be there to attack the fire, because within a few minutes, they mitigated it. But the smoke, which caused more deaths than anything else, rose up to like 20 floors. So there could have been deaths there that night. The management is infiltrating the Airbnbs because they have a vested interest in it. There are several breaches of fiduciary duties. There's self-dealing going on there, and they're pretty much, and here's the issue going on starting next month. Every homeowner, because of the fire that started in the Airbnb unit, the increase will be minimum of about $300. For instance, my association was like $560 or whatever, so mine will be $856 per month. My main concern right now are the elderly. They may have to decide, am I going to get my medication or am I going to pay this association? They are set up to lose their homes. After $2,000, as we know that threshold, right now they have the right to put liens and foreclosures. My concern are the elderly. Some of the residents have been there for like 40, 50 years. They're scared to death. We need help. The Airbnb needs to be dealt with in the city. Thank you.
Thank you.
All right, I'll make mine quick, but
She
I
took
would.
most of your time, but go
She
ahead.
took most of my time. All right, I would like to ask if we could meet at another time, just due to the time constraint.
Absolutely.
Just to tag on to what Noreen did share, though, Airbnb has taken over the building. In short, the fire caused 7 days of no water, no heat, and so we had no amenities. We just had electricity. The building, they did not take care of us. The Airbnb they're not managed. They're not being vetted as far as the protocols that you guys allegedly have in place. There are protocols that are on paper, but they are not adhering to that, nor are they enforced. So as a result, we are now drowning. I will lose my home in a week and a half.
Sorry.
I don't have family here.
the city of Atlanta, Georgia, the state of Georgia have failed us. You failed us. Because the entire time the Airbnb has taken over, they are now the board. They are the entire board. We don't have one homeowner on the board. Part of our bylaws stipulate that you have to live there. You have to live in the building. Not one of them live. They live in Johns Creek. They live in Alpharetta in their warm homes. So the day after the fire, we didn't have water, gas, electricity. We actually had to go and buy water and knock on people's doors. Do you have water? Here's a jug. Do you have water? Do you have food? They didn't take care of us. But yet and still our HOAs have been raised 50%. $1,200 is what will be asked of us starting November.
Per month, some units.
And since Georgia has a law written on the behalf of HOAs, which I love NOAC and them just, oh, no, nothing, this is not true. It's not true. So the people you had speaking in the beginning, that's all nice and fluffy with whipped cream and cherries on top, those are not the facts. You should come talk to the people that live there. Walk through the landmark. Airbnb has taken over. Their vested interest is to get us out so that they can have the building. And we get that. We get that. Then you go to each person and you say, and I'm sorry I'm taking up too much of your time, but you go and you go ahead and you buy from the owners. You just don't terrorize us to get us out of there. To disagree with the management team is $1,500. A homeowner died there because of them. Someone was thrown out of the 15-story window of a stairwell. We have homeless people that come into the building. We have key fobs that we pay for to come into the building. And all of the locks are jimmied because they don't want their people to have to deal with that. We don't have access to any amenities. So the $600 that I pay from this month, starting next month, it'll be $900 a month, is electricity, water, and gas. Not only that, they've actually imposed a new water bill. So not only with the HOAs, now they're going to give us a new water bill. And they base that on the square footage of the unit. Now, if I had in my one-bedroom flat a bathroom, a tub, a toilet in every single room, then yeah, I can see them doing that.
Who is the management company?
It's Airbnb, Lulu Homes.
Lulu Homes, okay.
So if I will not take any more of your time, there's a lot. I've been emailing the city council, the state of Georgia, the mayor, the governor, and the janitors, anybody that'll listen, for over a year. If you don't find me and you see me on the street, please give me the $1.
Thank you. All right, John Torres, he's a professor down at LaGrange College, and I want to thank him and his class. They're actually doing some research for us on this this topic, and he was here and they had to leave, so do want to thank him. Kenneth Cody, and we are down to no time. Okay, you spoke last time, right?
Correct.
Are you going to add anything new?
Yes.
All right, 20 seconds.
Okay. My name is Michael Shepard from the Peyton Place Condominium Association. I already spoke about money going to private bank accounts, dictatorship, no meetings. I just wanted to add that several speakers today notated that within current Georgia law or even people's bylaws, you can have meetings, you can have special elections. We did all of that. We are still at a $20,000 plus lawsuit that's still pending a default judgment right now in Fulton County Superior Court. So I just want to say we definitely need something. If it's under the Real Estate Commission, that's already an existing entity. I would love for that to be further explored, and I'll even do my own research, as this is taking up pretty much the majority of my time in life right now. But once again, you've heard the lady speak just now about potentially losing her home, and her bylaws already state you can't, if you're going to be on the board, you have to be a member. Guess what? They don't live there. You have to be on that board, you have to live there, and guess what? They're violating that.
I would
And so we
think,
need that
I'm no
enforcement.
lawyer, but I would think that's going to help you in court. So
Yeah.
you're at 55
And then,
seconds.
all right, I'm done.
Thank you.
Thank you.
Can I just say my sister
No,
lived in
let's-
those
we're-
same condominiums?
Senator James,
and
we
her-
got to go.
her,
We have to go.
condominium was taken too. So we-
Shirley
her name-
Clyde Allen. We have to go.
Okay, I just need
Wait,
to know.
I get that. You can talk to him offline. We got more people that want to be heard.
I'm going to be brief. I live in the Henry County South End, Crystal Lake Country Club And we're actually a POA, and we're beginning to discover that we actually have more rights than what we've been given to believe. So I've been taking notes, and I just have two questions. I understood today that property owners have voting rights that cannot be suspended because of fines. Did I hear that that's already something that's in law?
We passed that last year.
Can you give me what law or code that is, so that, because we're in the process of having a
233, House Bill 233. I don't know the code section.
House Bill 233, okay?
Yes, ma'am. Last year's session.
Right.
This year's session, actually.
Okay, that was passed. All right, because we're in the process of gathering a petition to remove the board as we speak. We also have an attorney who's been doing inquiries to try to get answers to questions, and they're not answering them. So that's the second question, because we had an election. They talked about a quorum, no quorum according to the bylaws, and they chose who they wanted to be on the board without honoring the homeowners' request of who they wanted to be on the board. Okay, the second question I'm understanding is that we are a corporation with officers and all that. And so I'm understanding that it's supposed to be nonprofit laws are not followed. It's a huge issue. But I also understand that, may be wrong, that however, it's no regulation for overseeing corporations that are not following the laws established.
Yes, ma'am. You're at 2 minutes.
So they're not regulated, but there's laws, and it's a huge issue.
Yes, ma'am.
So with those issues, does that mean that they should be fined, the officers of the corporation, if they're not following the rules and bylaws? Should there be fines?
That's things we're looking at, yes.
Okay.
But just so you know, once you find the HOA, that means you as the homeowner would be paying it too. It's just like suing the city government. Your taxes go to pay what?
Right, but I also heard that officers could be singly responsible for any financial loss that may have been incurred because they didn't follow their fiduciary responsibility.
Okay. We're looking at all of it. So yeah. If you've got specific questions, you can email myself and Senator James, and we will see if we can get some answers for you.
All right, thank you.
But right now is not the time for answers, or questions, I mean.
All right.
Okay, Liz Ratcliffe. And I'm not trying to be rude, I promise. I want to make sure everybody gets a chance to speak, and we've got very little time left.
I didn't know that I was on this, but we have a board.
Speaking to that mic, ma'am.
We have a board that was that put themselves in place when the builders left. Our bylaws state that we were supposed to elect a board. We didn't know the exact point, but these guys just decided they were going to be the board. Last year, they held an election, and they said, oops, we did this wrong. We're gonna stay in office. This year, they held an election. They said, oops, we didn't get a quorum, which a quorum is not needed. They said, oops, we're gonna stay in office. So, concerned citizens have a petition to get rid of the board. Is there anything else that we can do?
Okay, thank you. All right, Norm Case, is that? Nope, okay. Michaela Page? Nope. Daniel Powers? Nope. Trey Threadgear?
Yes,
Threadgirl?
Thank you, sir. Committee, I'll be real quick. I live where Liz and Ann lives also. Basically, we have a committee that was unduly elected by David Black, his name, Arnold Cole, David Linton. They still on this board. Basically, they done raised our fees 3 times, from $1,200, $1,600 to $1,840, and we haven't seen anything done. So basically, we're trying to get them out of there, like I said, to do this petition. Well, we need some assistance from you all because there's a lot more going on that I don't want to discuss. But they fined an individual $21,000 for a project that David Black approved, and there's more to it.
Okay.
Thank you.
Thank you. All right, Jane Roberts. All right, that's everybody.
I think I can do this in 1 minute. Good morning. Thank you, God. Thank you, God. Hallelujah, for you all doing what you're doing. I'm a member of a national HOA advocacy group that has been studying HOA reform in 50 states since 2018. There are a number of the members of that advocacy group for Georgia that are here today, and some very well-informed and prepared and well-researched individuals on other state models. And there's a list of proposed legislation that they have drafted collectively from the 50 states, informed, nationally.
If you'll get
Can we set
that,
set a follow-up meeting for that group, that National HOA Reform Advocacy Group, to meet with you and you, Senator Matt and Senator James?
Yes, close enough. Number one, have them send us the list and the recommendations, and then we will do a follow-up meeting with that. Okay?
Okay. All right. Thank you.
Thank you. All right, y'all. Thank y'all. We're an hour over time. Who didn't get called? Oh, well, come on up. Hurry up. You got. Come on. 1 minute.
All right. My name is Correll Driscoll. I represent the Georgia HOA Alliance, and I'm a part of that national group, also with the proposed legislation. I had to take a 5-minute presentation and boil it down to bullet points. So I am a hybrid too. I used to be on the board, and I'm a member. I'm a co-founder of Georgia HOA Alliance with now Commissioner Marvin Arrington Jr., not Senior. And one thing that I've learned through my travels is that everyone is okay with the rules until it applies to them. Yes. So that's the number one problem. And profit over community spirit has been the prevailing problem for a lot of the HOAs. And I agree that there's enough blame or accountability to go around from the members to the board and to the industry. I place the core problem on the industry. The reason why is because we don't have, all management companies are subject to licensing or certification through the Real Estate Association, but not all of them are licensed. And so there's a different level of competency that exists in the organization. From the attorney firm's perspective, they're doing their job, trying to properly advise. They go after the money on behalf of the association. They do represent the association interests and not individual members. That was one of my arguments as a board member when we spent a lot of time in litigation. And so I would ask that the commission consider 2 things. We need an oversight organization with some teeth, with some power to enforce, right? Whether you place it under the Attorney General's office or the commission that protects individual rights protection, Consumer Protection Agency. Sorry, and if we could get that HOA court, that would help minimize the expenses that are on the backs of many of the members, right? I'm blessed to be a student of the governing dockets in my community because I was targeted, and I realized that these rules and these fines have been weaponized to either hush members up who are asking questions or to punish people who disagree on different policies. And so we need a transition policy between the declarants and the members, the up-and-coming board. I'm one of the original board members in my community, and if I wasn't the seeker of knowledge, we wouldn't have the Georgia HOA Alliance today, because that's an educational arm, and we leverage each other to learn more about governing communities, because there's an agreement between the management companies who represent the declarants for transition training. They don't see it through. They dishonor those contracts. And how many community associations have the resources to sue, to enforce them or force them to follow through on the training? And also the records. I heard someone testify to the fact that records are given to the board members. That's not true. I appreciate it. All right, and the notification comes long before, the requirement for notification comes long before litigation. Board members are not notifying members of meetings. They're not notifying members about increases of dues and discussions or even a special assessment. Because as members, if we're part of those meetings, we have a say-so in many of the governing documents. So I'll email the rest of this to you all.
Thank you.
And I'll look out for the next meeting, and I'll try to be at the front. Thank you.
Okay, thank y'all.
Okay.
Thank y'all. Meeting adjourned.